हेलो। अवेलेबल। मैं अवेलेबल। हेलो। हेलो। मैं अवेलेबल।
ಸರ್
हेलो।
ವಿನೋದ್ ಕುಲಕರ್ಣಿ ಅವರೇ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಸರ್ ವಿನೋದ್ ಕುಲಕರ್ಣಿ.
हेलो।
ಹಲೋ, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ವಿನೋದ್ ಕುಲಕರ್ಣಿ.
हेलो।
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಕೋಟಾಲಿಂದ? ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
हाँ ಮೇಡಮ್, ಈಗ ಸ್ಟಾರ್ಟ್ ಆಗಿತ್ತೇನು ಮೇಡಮ್?
ವಿನೋದ್ ಕುಲಕರ್ಣಿ.
ಹಾ ಮೇಡಮ್, ಬರ್ತಾರೆ, ಈಗ ಸ್ಟಾರ್ಟ್ ಆಗಿತ್ರಿ.
ಸರ್ ಯಾಕೆ ತುಂಬಾ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದೀರಾ? ನಿನ್ನೆಯಿಂದ ವಿಡಿಯೋ ಮತ್ತೆ ಆಡಿಯೋ ಎರಡು ನಿಮ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಷ್ಟೇ. ನೀವು ವಿಡಿಯೋ ಆನ್ ಮಾಡ್ಬಿಟ್ಟು ಮ್ಯೂಟ್ ಮಾಡ್ಬೇಕು. ಇದು
ಅದು ಯಾಕಂದ್ರೆ ಸ್ಟಾರ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಮೇಡಮ್. ಓಕೆ
ಇಲ್ಲ,
ಓಕೆ ರೀ.
ತುಂಬಾ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತಾ ಇದೆ ಸರ್. ನಿನ್ನೆಯಿಂದ ನಾವು ಆಫ್ ಮಾಡ್ತಾ ಇದ್ರು, ನೀವು ಆನ್ ಮಾಡ್ತಾ ಇದೀರಾ. ಇದು
ಆಯ್ತು
ಕೋರ್ಟ್
ಆಯ್ತು ಮೇಡಮ್.
ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಓಕೆ
ನಿಮ್
ಓಕೆ.
ಮ್ಯಾಟರ್ ಇದ್ರೆ ಅಷ್ಟೇ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಆನ್ ಮಾಡ್ಬೇಕು. ಯಾವಾಗ್ಲೂ ಆನ್ ಮಾಡ್ಕೊಂಡು ಕುತ್ಕೊಳ್ಳೋದಲ್ಲ ಸರ್. ತುಂಬಾ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತಾ ಇದೆ ಕೋರ್ಟ್ಗೆ.
ಹೌದ್ರಿ. ಓಕೆ ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್
ನೀವು
ಯು.
ವಿಡಿಯೋ ಆನ್ ಹೆಂಗ್ ಮಾಡ್ಬೇಕಿಲ್ಲ ಮಾತಾಡಿದ್ವಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಮಸ್ಕಾರ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ನಮಸ್ಕಾರ ಮೇಡಮ್. ವಾಲ್ಯೂಮ್ ಕೊಡ್ರಿ
ಸರ್ ಹೇಳಿ ಸರ್.
ಮೇಡಮ್. ನಾನು ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಮೂವ್ ಮಾಡ್ಬೇಕು. ನಾ ಸ್ವಲ್ಪ ಅಲೋ ಮಾಡಿ ನನಗೆ.
ಫಿಸಿಕಲಿ ಮಾಡ್ಬೇಕು ಸರ್.
ಏನಂತಾರ?
ನಿನ್ನೆ ನೀವು ಮೆಮೊ ಸಾಹೇಬ್ರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಲ್ಲ.
ಏನ್ ಮೇಡಮ್ ಕೇಳ್ತಾ ಇಲ್ಲ ನೀವು?
ನಿಮ್ದು ಬಂದಾಗ ಅದು ಅಂಗಡಿ ಬಂದಿತ್ರಿ. ಹಲೋ. ಮಾತಾಡ
If my lords leave me not, one PL matter, my lord. Last occasion I moved the matter, my lord. It was posted on June 2023. A civic community site, my lord, was allotted to the third parties, my lord. They are constructing the building in the property in question. I moved the matter on the last occasion. My lord suggested me to file an application. Accordingly, I filed one application, my lord, on 1/8/2024, my lord. Can I request, my lord, to take up this matter any day next week, Monday or Tuesday, my lord? They are going on with the construction. Though they served with the notice, they did not represent it before this honorable court.
23rd. 23rd.
In this case, Lord, the reward base types have been ordered to be able to 25 play. I filed Lord on first day. Tomorrow, 7 matter.
3rd of September.
There are in all, about 800 employees are employed. Livelihood, they are out of school. Just they are existing.
Not possible. Yes.
Mines and minerals matter. Mines and minerals matter, my lord, while I am the licensing, but I am not able to work because the illegal person acquiring illegally, threatening me from entering the property itself, my lord. That's why I need a police protection, my lord. I have complained to the authority. In the meantime, my lord, authorities are also issuing notice.
6th September.
A writ appeal, my lord, the matter was directed to be posted immediately after vacation. It was not posted, my lord. Any date may be given. The writ petition, my lord, what had happened is that the benefits that were given to the workmen were unilaterally taken away.
Some date must have been given.
No, my lord, it was only stated that it was before the Court Hall 2, my lord, at that point of time. It is stated that it is to be posted any date after vacation, immediately after vacation, my lord. So any date, any
13th September.
earlier date, my lord, please.
My lords, this is a fresh education writ appeal, my lords, wherein the learned single judge has passed an order without considering our contentions and the necessary party, that is KEA, my lord. Learned senior single judge has imposed 12 lakhs of cost and also directed to transfer certain amount of seats to state quota, my lord. My lords, tomorrow the government,
Quota
my lords,
transfer to which quota?
transferred to the state quota from the management quota, my lords.
What seats?
Seats, my lords, medical seats, my lords. My lords, my lords, to
21st. 21st.
my lords, tomorrow the government has called for appropriation of seats, my lords. There is a grave emergency, my lords. If not,
Tomorrow what is going to happen?
my lords,
Tomorrow what is going to happen?
there is,
Yes,
Apologies.
yes.
My lords, the government is drawing up the seat matrix, my lord. If the government is to draw up the seat matrix, including these seats, the institutions will be affected because of the funding, my lord. We are already making over seats to the state governments because of the views expressed by the learned single judge. The government is intending to appropriate these seats, which will ultimately lead to a gross imbalance in the fee structure and the
So seat matrix is going to be fixed tomorrow.
They have been, yes, my lord, they've been asked to drop the seat matrix by tomorrow. That's what.
Tomorrow.
Great.
This is a writ appeal challenging the
Number 19.
19.
19. It's a matter, my lord, heard this matter pertaining to the PF, my lord. The corporation has filed 2 appeals. My lord, yesterday the PF council has filed their objections, my lord. I have to go through that, my lord. Your lordship may 2 weeks time.
September, to go in September, 20th September.
My lordship, serial number 41, my lordship.
Yes.
Serial number 38, appearing for
38.
appellants. Appearing for appellants. Seeking for a short accommodation. Yeah.
20th September.
So the interim order may kindly be extended.
Interim order operating in the appeal shall continue to operate.
Grateful, my lord.
Serial number 41, my lordship.
Yes, madam.
I need 2 weeks.
Yes, madam. 6. What do you want?
Serial number 6 for the petitioner hearing for. The counsel on record is not available today, my lord. 2 weeks time.
6.
Serial number 6.
And 24th of September. At the request of the appellant, whom I had asked for, send over to 24th September.
Serial.
Challenging the order passed by the single judge. Wherein
Pardon?
I am the secured creditor. I invited the tenders for sale of the mortgaged property. The respondent participated initially, paid the EMD amount. Thereafter voluntarily absented. Therefore, I forfeited the EMD amount, against which a writ petition filed, which has been allowed. my lord.
What do you want?
My lord,
What do you want?
I filed this appeal for quashing of that order.
What is filed? A petition.
My lord,
What is filed?
writ appeal I filed.
Little
Writ-
louder. Little louder, Mr.
I filed a writ appeal praying this honorable court to.
All it will released on 19th September, yes.
My lordship, serial number 41, my lordship. 41.
41, yes.
Request for 2 weeks accommodation, my lordship.
25th September.
I appear for petitioners, appellant. Interim
Lord,
order to
serial
be
number
extended.
8.
Interim order to be extended. And
Serial
number.
Serial number 8, my lord, my land. I'm for the respondent. My
Lord,
and is the appellant, my lord. So it's a dispute between the bank and the employee.
Serial number?
8, my lord. 8.
It's serial number 8.
8.
It has been settled, my lords,
Settled.
between the
Employee and
appellant
bank.
and the respondent, my lords. My lords may kindly have it on 28th of this month, on
20th.
Tuesday, my lords.
20th.
Please.
Please,
We'll
on
report.
20th, my lords. So they will,
20th August.
Much obliged.
please.
Number 13, my lords, I appear for respondent number 2. I request the matter to be taken up tomorrow, my lords. The arguing counsel. Is a panel. 1-3, my lord.
1-3.
Please. I'd inform the counsel for the petitioner. They requested it to be tomorrow.
Maybe at tomorrow.
Yes, yesterday it was there.
Please, my lords.
So when do you want?
Tomorrow, my lords.
Tomorrow. 22nd.
My lord, I'm for appellant. In that case, I've sought an interim order. Is eviction order to vacate the premises yesterday, my lord.
But
Therefore-
tomorrow,
Tomorrow.
22nd.
Highly obliged.
Lord, serial number 31, my lords. Serial number 30.
Yes.
Serial number 67, my lordship. My lordship, similar matter is to be posted on 21/11, my lordship.
What is posted on 22nd?
This is education matter relating to admission, my lordship. And the similar matter was posted on 21/11. Maybe it may be also posted on 21/11.
21/11. 21/11.
Please, my lordship.
No, let it be called.
Okay, please, my lordship. Please.
Your lordships, serial number 32, your lordships.
Yes.
My lords, serial number 31, my lords. Appearing for the complainant, seeking for short accommodation, my lords.
31.
Yes, my lords.
So what do you want?
Short accommodation, my senior is not well.
Accommodation. At the request of the honorable complainant and on 26th September.
With the permission of this honorable court, may I post for memo? Admission for the dental college for the PG.
Student matter.
uh,
What is the urgency?
Well, from the institution for the admission, we have moved the application for the admission enhancement of the PG seats. It has posted delayed for 2 days, so they have not considered our application. Hence, we have filed this petition.
21st.
Yes, 21st.
21st.
Much obliged.
My lords, I am Dr. Vinod Kulkarni, a psychiatrist and an advocate from Hubli.
Yes. Yes, Mr. Anybody wants to mention online?
My lords,
Your lordship,
Through VC, sir.
your lordships, serial number 32, your lordships.
32, yes.
Yes, your lordships. I would like to pray for short accommodation, your lordships. For respondents, your lordships.
You are Amrutesh,
Yes, your lordships.
at the request of learned advocate Mr.
Yes, four-
compliance and
I'll file my objections also, your lordships. 4 weeks time may be granted, your lordships.
27th September.
my lords, I am Dr. Vinod Kulkarni, psychiatrist and an advocate from Hubli. I'm a petitioner in PILs. One is for mental health, other is for PG need counseling. It is not being listed since 3 years. I request you to kindly list it either tomorrow or on 20th of this month, my lords.
You file interim application, otherwise not possible. Yes, start.
List number 2.
You file interim application, Mr. Party in person.
My
And
lords,
come with the certificate.
a lot
and
of
the
people
rules.
are committing suicide for the wrong act in Mental Health Act.
You file
Lot-
interim application. If you want to prepone the date, yes.
So list 2, seal number 1. To Malay MR.
My lord, appear for the petitioners. Petitioners are applied for a medical course, MBBS seat. In respondent number 5, KE authority through UG NEET counseling. My lord, they are even though qualified under persons with disability quota, PH quota, persons with handicap quota, but they have been denied the admission. Denied for counseling also. So my lord, kindly.
Earlier some order was passed?
No, no,
No, my lord.
Notice.
only notice was ordered, but this may have, they have given 40%, but they made not eligible for medical. Perhaps, my lord, the ostrich tree that have gripping and all, my lord, might not have been done. It may have to be referred.
So where is that your certificate?
My lord,
My lord, as per MCA guidelines 2018, 40 to 50% is eligible for admission to medical and engineering course, my lord. Please, page number, please refer MCA guideline 2018, page number, my lord, 39.
But serial number 14, my lord, is the petitioner. There, my lord, they arrived at 45%. They said something about the disability, which I cannot, my lord, decipher. Not eligible, last but one, not eligible for medical PH and not eligible for veterinary. And this, what my learned friend is relying upon, that notification is inapplicable. The 2019 notification is there. The other day, your lordships.
We passed some order.
Yes, referring them.
Qualitative.
Yeah.
Medical exam.
Yes.
So where is that order?
I have not got it yet. Interim order.
Interim order.
That was.
Qualitative medical exam. So we'll provide for same.
Yes, your lordship is saying.
5-member team. 5-member team of which college?
Yes,
Which-
it's.
Which hospital? Government.
From Bounding Institute, same.
Same qualitative exam.
Yes.
So when you will go?
My lord, they've already got a certificate from
For re-examination, when will you go?
tomorrow only.
16. Let it, you go on 16. 16.
Yes, 16. That's 16.
We'll post the matter on 22nd.
Yes.
16.
16th and 22nd. Process is going on, admission process.
Yes, but not just started, but the
They can, my lord, upload their options, there is no problem.
I'll just take it.
But my lord, there is a list of testing institutions.
Report may go on 20th, since 16, 20.
19th also,
19th.
holiday, okay.
20.
I'm sorry, 20th.
20th.
My lord, there is a list of institutions which are recognized by the MCI for testing and admitting for medical education. My lord, in the previous year, in the same similar matter, one student was
Which is government.
admitted accordingly as per the
So we'll go to the Powering Institute.
Powering
on
Institute.
16th of
Yes.
August.
if your lordship permit to go to
Offer yourself for examining. And we are
Chennai.
passing the order today.
Yes.
We'll pass the order, right?
great.
My request, my lord, 16th at 11 in the morning. Specific time, so that.
Mara.
Order copy ತಗೊಳ್ಳಿ. At any time, my lordship suggests,
इसमें किया था वही करेंगे 10 at 11.
please.
Where is your certificate? Showing 45%. What kind of disability?
Page 11.
Annexure A, my lord. 11.
What kind of disability you are suffering?
Locomotor disability, my lord.
Locomotive.
42.
Here it says, Lord,
Left-sided infinitum with left elbow deformity. The shortening of lower limb. 45% in relation to her left lower limb. As per government.
My lord, 40 to 80% is eligible in between. As per medical guidelines 2018 and a recommendation of a high expert committee. Kindly see annexure.
And
D,
where
my
is
lord.
their, where is their communication treating you to not eligible?
Kindly see annexure D, my lord.
No, annexure, you must have communicated.
no, it's not committed. We have produced a list, Lord, yes, the list he has produced. In the list, my lord, list is at B3, my lord, page 28.
B8.
Sorry, my lord.
Actually, MCI has recognized around 18 institutions. In that institution only that test should be done and produce the certificate. In the previous year also, the candidates did the same thing and produced a certificate from these institutions. After considering that disability certificate from these institutions, the Honorable Court allowed the petitioner to get the admission in the medical college in the previous year.
It is 40 to 80%.
Yes.
In between for medical.
Medical. 40 between.
This is
could be
45.
Not between 40 and 80.
48.
So this is
Between 40 and 80, but my lord, for locomotor disability, there is an ostrich, my lord. Yeah, your lordship, sir. I'm sorry, but I have only one copy. This year, he has produced the earlier notification. In the locomotor disability, he comes under others, my lord. And there is the ostrich wallet down below. They have to assess for that grip and all, my lord. though it is 65%, if those grip and all are not there, my lord, they made him ineligible. Let it be assessed, my lord, again, having regard to this notification.
But my lord, it is not assessed by the institutions which are recognized by the Medical Council of India.
This is by a team of doctors, my lord. We go by their assessment.
It heard learned advocate Mr. So and so for the petitioner, learned additional government advocate Mr. Sudev Hegde for the respondent state, and learned advocate Mr. Ramesh for Karnataka
Examination.
The petitioner herein is an aspirant to pursue the course of MBBS. The petitioner happens to be a person with disability who has full stop. She is diagnosed with left-sided infantile MP paresis. Here, page 11, left underline. With left elbow deformity, with shortening of left lower limb. The permanent disability on the aforesaid count is assessed to be 45% as per the disability certificate issued. Disability certificate dated 21/5/24 issued by the General Hospital, Soraba. Any of the disability to the extent of 45%, which is a locomotor disability, the petitioner is treated to be not eligible to be admitted to the MBBS and veterinary course.
Medical and
Medical, my lord.
medical and veterinary, both.
Medical.
Veterinary courses. While the petitioner is not communicated with the disability, learned advocate, Mr. Learned advocate KEA produces a statement showing the details whereby the percentage of disability of the petitioner is shown to be 45%, and he is treated to be not eligible medical courses. It was submitted that so the permissible extent for addition to permissible extent for disability for admission to medical courses is between 40% to 80%. When it comes to the locomotor MOTR disability, which the petitioner has, the standards are differently described. Paragraph. Learned advocate for the petitioner would submit that as observed by the Supreme Court in Bambania Sagar. Of Surambai versus Union of India, which was special leave petition number 1817 of 23, decided on 3/10/23. The case of the petitioner is qualitatively examined and the medical opinion with reasons to treat the petitioner disabled for the MBBS course has to be obtained, has to be given. There is no gainsaying that the petitioner is only qualitatively examined. In the aspects of qualitative nature of disability, nothing is on record. An expert reasoning on the said score is required. And here a paragraph says of this in light of the totality. 5.1. Same direction. 5.1, 5.2, 5.3. Changes किए हैं, necessary changes. Keep this. So from paragraph 5.1 on, same, just copy it. Except this change in the dates. Copy of the order to be available to you. Right. If any difficulty, ask. Yeah. Twentieth.
Great.
To go on 16th and you exam. Yes.
Great, my lord.
16th.
Number 2? The same matter, madam. Connected with the same.
Same matter.
Yes, my lord. Similar.
A locomotive disability, Lordship may kindly take Annexure A, page 11, my lord. Disability is
65%.
65%. But when our team of doctors examined, he has only 20%, he has only flat foot. Either this is wrong or that is wrong. Because in these cases, lot of
This, my lord.
50%. So
only flat foot he has not entitled for PWD at all. That is the our assessment.
not eligible.
Not eligible at all. 20% not eligible, but not eligible for PWD quota. General he can go in general.
But this is a certificate issued by the one of the recognized institution, my lord, recognized by the MCA.
What is flat foot?
Flat foot is common, my lord. It's for everybody. It will be there. Many of them have suffering from. It's not suffering at all.
Handicap in the leg. Yes.
It may be reassessed, my lord. I have no. And in this case, my lord, in the certificate, there is a hand. disability of hand is also mentioned, whereas it is not there in our assessment.
Locomotor disability relates to legs and hands, my lord.
Sometimes, my lord, the impersonations happen. Lot of, my lord, misuse is also being done. That is what, my lord, our experience. Let it be reassessed, my lord. I have no objection. Let it be reassessed.
But let the same exercise be done.
Yes.
Same exercise.
Yes.
Of examining.
Yes.
The same order instead of she, it is he. So he is suffering from locomotor disability, which is diagnosed as short limb left, page 11 perhaps, short limb left, lower limb right wrist, contracture, stiffness, congenital deformity. Certificate date is 10/3/23. And extent of disability is 65%. You have to add that as per the authorities, he is found to be having the flat foot with 20% disability, therefore liable to be treated to be not eligible for medical courses. And both artists saying, हो जाएगा?
But my lord, there is a serious allegation. The KEA is not doing properly with these testing and all with respect to disability quota. That's why they have come up before the court.
So here also you go on the same date,
So,
same direction.
Same day.
yes.
Both are on 20.
Great, my lord.
Oblige. We'll cover.
List 1 contempt matters. Bill number 1, with Chandrakant R. Patel.
Appearing for the complainant. But based on the direction issued by the learned single judge of this honorable court, the complainant gave representation by annexure D before the my lord respondent, my lord, which is not considered.
Initiated or not?
Lord,
Proceedings are initiated.
pardon,
What is not done?
the representation which is not considered by the Commissioner, City Municipal Council, Chikmagalur.
Directed to initiate the appropriate action.
Please, please, my lord.
It is done or not done?
Not yet done.
Notice returnable on 26th September.
This still number 2, Somchekhar.
Lord, I appear for the complaint. Lord, learned single judge is directed to consider the application for conducting podium durast. Lord, the
Notice returnable on 1st October. 1st October is vacation. 1st October is vacation. First.
Number 3, it's a PL matter. So
Appearing for the petitioners, my lord. My lords, the petitioners are the residents of Bhadravati Taluk, Shivamoga district, my lords. They have filed this PIL on the irregular running of a school, government aided school in their district, my lords. Without following any rules of imposed by the government, and also against the laws, they are running the school, my lords, without providing basic infrastructure to the school. And also, my lords, during the grant of license, my lords, Annexure C, typed copy is at page number 28. It is mandatory to maintain own building, my lords, but also they are running in a rented premises, my lord. And also, kindly look at Annexure E and F, my lords. The infrastructure, my lords. The washroom facilities are also not maintained, my lords. No playground is maintained. And also regarding the safety of the children, the NH is close by to the school, my lords. NH is very close to the school, my lords. No safety for the children also.
What is close to the school?
National highway, my lords. Bangalore on our national highway is also very close to the school, my lord.
Who are you?
We are the residents of that district, my lords. No,
What do you want? So inviting order or you are going to authority? You are not inclined.
my lords, at least the respondents may consider my representation, my lords.
Every now and then we can't interfere in such matters. If you want to go before the authorities to pursue representation, you are free. We'll permit you.
Sorry, my lords.
If you want to pursue your representation, we'll permit you.
Please, my lords, at least my representation may be considered by the
Provided you withdraw.
my lords.
Provided you withdraw, otherwise we are dismissing the bill.
My lords, the authorities have not, lives of the children are at stake.
Sir,
My lords.
what do you want? Inviting order or you want to go for representation? Decide. We are not inclined to grant any relief.
No, the lives of.
If you want to go before the competent authorities with your grievance, you can go by withdrawing the petition.
Please, my lords.
Learned advocate seeks permission to withdraw the petition, stating that the petition would opt to pursue the representation already made to the competent authority respondents in relation to the grievance raised in this petition about the functioning of the school and the infrastructure available in school. Reserving such liberty, the petition is not entertained if the representation is made. It will be open for the petitioner to make a fresh representation. Also, the authority may consider the pending representation or the fresh representation as may be submitted by the petitioners and take an appropriate decision in accordance with law after undertaking due inquiry. Disposed of accordingly. Yes.
Cell number 4. Sumo to PL.
One matter.
So,
Please.
all are there, companies are there. That we'll put off, we'll devote time after in the first week of September.
One submission.
Say last week of August, 29th August.
One submission at this stage.
Yes.
Yes, recently I had an occasion to visit Africa, and there I inquired with the people there as to how they are managing the affairs. They have invented a very simple device, mirror. Honeybees, mirror, they are attracted to the tears of the elephants. Honeybees, mirror, they are attracted to the tears of the elephants. And so therefore, these parts, mirror, they raise honeybees there and they are interconnected by wires, normal wires, not power wires. So if the elephant comes near them, the wires are shaken. The next photo may kindly be seen. The honeybees come out. The moment they see honeybees coming out, they run away from the scene. Very simple method. And then Miller, they asked, what do they do? Then they say that drones they have adopted, Miller. In the drones, they give the sound of the honeybee. So without there being honeybee, if honeybees is there, the additional income for the tribals there. If honeybees are not there, Miller, these drones are used, Miller, even this is a photo taken in the night. So these photos, elephants, they run away on hearing the sound of these drones, Miller, emitting the honeybee sound. So this is a very simple method by which they can do that, because solar energy, Miller, that has been prohibited by the Honorable the Government of India, Miller. And that has been, in fact, I have given the judgment, Miller, the last occasion. Okay. Madam.
I'll ask them here. My lord, could kindly see. Page 7 may kindly be seen, my lord. Which is that they have given us. Judgment, the middle of that means, where is it? By the other letter, my lord could get it means. By the other letter number so and so dated 11/11/2009, issued by the Government of India from its Ministry of Environment and Forest, Project Elephant, addressed to the Chief Wildlife Wardens of all PE states, a specific direction has been given to ensure that no solar power fencing is erected in future. Specific direction. And that has been accepted here in page 8, my lord will get it, paragraph 18. In the above background, we have already issued a direction on 4/11/2009, directing the respondent to ensure that no fresh solar electrical fencing is erected in future, and the said direction is hereby confirmed. But in the statement of objections they have filed, they have said that they are putting up solar fencing, my lord, that may run counter to this direction issued by the honorable, by the central government. That may also be examined by the state government, my lord, before they file additional objections. So yes, let them examine that. That's why I have.
We'll consider.
Please, sir.
May I request in the first week of September, my lord, we'll examine all these aspects.
For September.
Fourth, grateful.
And over to first. Fourth. Of course.
It's a green bench matter, it's number 5, the Ganpati Bhatt.
In this case, my lord, I have challenged, my lord, the grant of burial ground in my quarry list area by the deputy commissioner is the, my lord, challenge before this court.
27. The dictation. Don't follow. Don't follow. 22nd. We'll tell the editors. Yes.
My lord, the ink page number 31, my lord. 30. That is, my lord, the quarry list which is granted in favor of the first petitioner and my lord, second and third petitioner in respect of survey number 110-8 measuring 20 guntas, 30 guntas and 20 guntas. This is, my lord, my lord, quarry list has been executed in favor of the petitioner number 1, 2, 3, my lord. Kindly see, my lord, the after grant of quarry list, my lord, I'll draw your lordship's attention to annexure D. That, my lord, ink page number 175 may kindly be annexure E1. Annexure E1, my lord, is the area in which, my lord, the quarry list has been granted to the petitioners. And, my lord, subsequent to that, the deputy commissioner, ink page number 177, annexure F, translated copy, my lord, 179. The same area which is granted to the quarry list area to the petitioner has been, my lord, reserved for, my lord, for burial ground. My lord, we have given several representation. I will draw your lordship's attention to, my lord, ink page number 185. Earlier that annexure E1 I have shown. This is the burial ground at ink page number 185, annexure F1. This and, my lord, the quarry list which is granted annexure D, ink page number 175 and 185, the same area which is granted to the petitioner. My respectful submission is, my lord, kindly see the, my lord, during the pendency of writ petition that they have constructed, when we have given a representation, annexure G, ink page number 189, kindly be seen. There are small puja room also has been constructed middle of the rocks. In page number 189. We have given several representation to the Deputy Commissioner and Mines and Geology Department. Starts from in page number 190. Either, my lord, that they have to give alternative, or, my lord, that they have to remove this, my lord, the burial ground which is granted. The people are coming, and, my lord, now all the activities started. And, my lord, we can't carry out queries because however they are dead rent and all these things, my lord, respondents are claiming. Therefore, I have sought, my lord, the quash of annexure F, which is, my lord, granted, my lord, for burial ground in page number 177. The same area which is granted as per annexure C, C1, C2 queries, which is, my lord, reserved for, my lord, burial ground, and now they have, my lord, constructed some sheds for puja and other things. I can't carry out queries. Mines and Geology Department is not taking any steps either to remove that or, my lord, to grant alternative, because this is huge land, about survey number 128, about 85 acres. And in the same rocks, my lord, that they have granted. Under those circumstances that we have no alternative, we have paid, my lord, required fees, say query lease has been executed in our favor. And we have brought all these things to the notice of the respondent authority by giving representation. Representation, my lord, is which is given at ink page number 190, annexure H. Translated copy, my lord, 192. That is 21/10/11/2020 onwards that we keep on giving the. We have given, my lord, the mine, the Deputy Director, Mines and Geology, and Deputy Commissioner, Assistant Commissioner, everyone that we have given representations, but no action has been taken, my lord. I can't, since, my lord, they are claiming dead rent from me, and, my lord, I can't carry out the activities by virtue of this. People will, my lord, start hesitation. If they are granting alternative lease, I have no objection. Otherwise, my lord, this annexure F to be stayed.
To seek instructions and get back to my lord.
Already notice was issued, but my lord, earlier advocate is not there. Short date may
It's
be
a
given.
flesh matter. There's nothing here.
Made in this writ petition is to set aside order dated 4/11/2020, whereby land survey number 128, head measuring 2 acres, abutting the property of the petitioner supposed to be as quarry, whom I granted in favor of this one right.
Deputy Commissioner directed to, my lord, Gram Panchayat officer too.
It is an order passed by the Deputy Commissioner. Full stop. There is a further prayer in the petition directing this number 4. Yes, the senior geologist to ensure that the quarry is granted in favor of petitioner should not be disturbed by any other order. Petitioner 6 to provide police protection as well.
Yes, please.
The court has gone through with the help of learned advocate Mr. So-and-so.
Well, I was thinking what's wrong with it.
Petitioners and learned advocate, learned government, additional government advocate, Mrs. Srimati Nilofer Akbar, who assisted the court upon service of copy of the petition in advance. Only aspect which the inclined to examine is whether the area granted in favor of the discount rate, which rate overlaps the area of the lease of the petition. Full stop. For this limited purpose, whether the both areas are overlapping or not. The notice is confined to the said aspect to be issued to the respondents, returnable on 30th August.
My lord,
Please.
the hand delivery of the copies.
Additional government advocate shall take instructions on the aforesaid count on the next day. And if so, choose, file the affidavit.
Much.
Obliged, man.
6 urgent, seal number 7, the writ appeal matter. The Saurabh Barke.
Lords, an impleading application has been filed. I collected the copy just now. Lords, I was instructed to appear in the matter, but at this stage, I did not get ready, my lords. Since the AG is appearing, I presume that the matter will have to be heard on merits. If your lords were to accommodate till Monday or Tuesday, my lords, I'll get ready. Because of the stage of the case, I did not get ready, my lords. My sincere apologies.
Having obtained interim order from the Honorable
Monday,
Court.
Monday or Tuesday, my lords, if your lords.
Lords, may I submit, my lord? I have filed the impleading application, my lord. I have engaged senior. Kindly pass over, my lord.
No,
I have
let
engaged-
it
I
be
have
on Monday
engaged-
if my learned
I
friend is
have
also.
Senior counsel, my lord. He's on his legs, my lord.
Please, my lords. My apologies, my lords, that of course, to the Advocate General also. I didn't know, my lords, the Advocate General would be, otherwise I would have been prepared.
Let this appeal be posted to be considered on Monday.
Lordships.
That is 19.
There's an undertaking given, my lords, if it could be extended till the next date of hearing. Please.
It's a very simple matter. I don't know why it's going on.
8 urgent, seal number 9, the B Vachan.
Petitioner's appeal, my lords. The petitioner had applied for allotment of site to respondent number 2, Housing Board, my lords. The petitioner, the appellant had been waitlisted at serial number 8, my lord. Annexure B, page number 38, my lord. As per regulation 9 of the allotment regulations of the Housing Board, my lords, if there's an option for the board to waitlist allottees. Accordingly, my lord, I was waitlisted at serial number 8, my lords. In the year 2012, this was in 2008, my lords. In the year 2012, site became available for allotment by virtue of cancellation of an existing allottee, my lords. I was eligible for allotment, my lords. Notwithstanding my eligibility for allotment in 2012, my lord, I was not allotted the site. Eventually, my lord, I was allotted a site in the year 2021 at the rates of 2021, my lords. My allotment, if I had been done in 2012, I would have been eligible for allotment at rupees 550 per square feet. In 2021, my lords, when I was allotted a site, I was allotted at the rate of 2,000 rupees. My lord, the learned single judge
No records are available.
I have no, my lords, for obtained the Right to Information Act. I filed it along with an application in which, my lords, have produced a copy of the cancellation letter issued by the Housing Board in the year 2012 itself, my lords. This cancellation, my lords, was done at the request of the then allottee, my lords, by name Shrimati Tayamma. She had requested for the cancellation of the site, and, my lord, subsequent thereto, pursuant to that request, my lord, a cancellation had been done.
Notice returnable on.
Obliged, my lords.
12th September. 12th September.
Please, my lords.
Seal number 10. Sylvia, Dr.
Please, Madams. Respondent will kindly pass over the matter. Senior held up in other report. Senior is held up. So it will go to 26th of September. As 10 down to 26th of September, as requested on behalf of learned review the appellate. Next.
26/9.
So, Lordship, kindly give me 25th or 27th.
25th. 20.
I'm grateful.
Seal number 11.
May please, the challenge, my lord, in this writ appeal is to the order of the learned single judge. This, my lord, is the matter relating to Uber and Ola, my lord, and the question of fare fixation by the government.
Yes, what is the notification 25/11/22?
Beg your pardon?
What was under challenge in the main petition?
Well, the fare notification issued under the Motor Vehicles Act is dated 25/11/2022. Can I request my lord to kindly come straight away to that document, which is at page number 490, volume 3, my lords.
Yes, 490.
490. The translation is there. May I just take your lordships to that, my lord? Fare notification. Actually, fare fix. Page.
So what is this aggregator service?
My lord, aggregators as defined under the Motor Vehicles Act are intermediaries. Intermediaries, my lord, or an online marketplace, which, my lord, does not actually own the taxis themselves, but provides, my lord, a platform where a taxi driver or a taxi owner and, my lord, the customer can interact and enter into a transaction whereby, my lord, the transaction of actually hiring the cab is achieved. So we provide that overall transaction, that overall platform in which, my lord, this transaction can be achieved. It is, my lord, identical, if I may say so, to an online marketplace like Amazon or Flipkart.
So it permits you to, permits the authorities to charge 5%.
That is what has been done. And that is what is challenged. What, in my respectful submission, Lord, could have been done according to us is that as a transport department of the government of Karnataka, you can fix the fare. The fixation of the fare, my lord, is with respect to the permit holders. In the case of a contract carriage, the contract carriage permit holder is one who is covered by section 67. An aggregator, my lord, is not a permit holder because I don't hold a permit insofar as a motor vehicle is concerned. And therefore, I am not in a position to actually be controlled by a fare that is fixed by the government. For which, my lord, there is a separate provision made under the Motor Vehicles Act, under section 93, whereby, my lord, if your lordship, I must of course give your lordship a little background. When this whole concept of aggregators started, the state government came out with an aggregator rules in the year 2016. Those rules were challenged and is subject matter of an appeal before your lordships, where the learned single judgment struck down certain provisions and some provisions were upheld, and that is subject matter of a writ appeal, and that is pending before this honorable court. The Motor Vehicles Act was amended, by virtue of which the definition of an aggregator was added into the Motor Vehicles Act by the central government. Can I request, my lord, can I take the Motor Vehicles Act now? I'll quickly take your lordships through how this scheme has evolved. Can I humbly request, my lords, to look at section 2(1)(a), 1 capital A. Lords have it. ಯಾವ year? ಹಳೆ book ಆ? 2(1)(a), my lord, of the Motor Vehicles Act.
That is adapted vehicle?
I beg your pardon?
2(1)(a) is what? Aggregator.
Aggregator. Aggregator means a digital intermediary or marketplace for a passenger to connect with the driver for the purposes of transportation. Similar, my lord, to an Amazon, which is a marketplace which connects a buyer and a seller for the purpose of achieving a transaction. Aggregator is also defined to be an online marketplace. Now, please see section 93. That was also amended in the year 2019 when the definition of aggregator was first brought in. '93, my lord. The heading of 93 earlier was agent or, I'm sorry. Before 2019, the heading was agent or canvasser to obtain a license. That was modified, my lords, to say agent or canvasser or aggregator to obtain a license. Your lordship now see the language of the section itself. No person shall engage himself, one, as an agent or a canvasser, in the sale of tickets for travel by public service vehicles, or in otherwise soliciting customers for such vehicles, or as an agent in the business of collecting, forwarding, or distributing goods carried by goods carriages, and 3, as an aggregator, unless he obtains a license from such authority and subject to such conditions as may be prescribed by the state government, provided that while issuing the license to an aggregator, state government may follow such guidelines as may be issued by the central government. Now, central government has made those guidelines, and that is present, my lord, but of course they do not follow it. Provided further that every aggregator, and this is important if your lordships may kindly see this, provided further that every aggregator shall comply with the provisions of the Technology Act 2000 and the rules and regulations made thereunder, which makes us, my lord, an intermediary under the Information Technology Act, which is what, my lord, ultimately your lordships know in Shreya Singhal and all the other judgments was considered. Then, please see 2, my lord. The conditions referred to in subsection 1 may include all or any of the following matters. A, the period for which a license may be granted or renewed. B, the fee payable for the issue or renewal of the license. C, the deposit of security of a sum not exceeding rupees 50,000 in the case of an agent in the business of collecting, forwarding or distributing goods carried by goods carriages, of a sum not exceeding 5,000 in the case of any other agent or canvasser. D, the provision by an agent of insurance of goods in transit, the authority by which and the circumstances under which the license may be suspended or revoked, or such other conditions as may be prescribed by the state government. And therefore, my lord, these conditions as may be prescribed, other than the rules for aggregation made in the year 2016, there are no other rules made after the amendment in the year 2019. And the 2016 rules do not prescribe the fee that has to be paid to the aggregator. The point really, my lord, was whether this provision is applicable in the context of fixing a fare for the aggregators or not. That is one part of the argument which was advanced before the learned single judge. The other, my lord, was, can you exercise section 67 of the Motor Vehicles Act in order to fix a fare or a percentage of the fare for an aggregator who is exclusively covered under section 93? Can I now request my lords to kindly come to section 67? And Lord, we'll see the chapter under which it is. It is Control of Road Transport, section 67. Control of Transport Vehicles, chapter 5. If my lords look at section 66 first, the necessity for permits is provided for here. And these, my lord, are the 3 permits which my lords would be aware. A contract carriage permit, a stage permit, and a goods vehicle permit. And those are the 3 permits, my lord, which are issued under the Motor Vehicles Act. Conceptually, therefore, my lord, before the concept of aggregator even came on the statute book, there was only 3 concepts of a stage permit, a contract carriage permit, and a goods carriage permit. There were no other permits which were available. My lords may now look at 67 in this context. And this is, my lord, the power exercised by the state government to fix a particular fare. A state government, your lordships have, my lord, I think my lord justice. A state government having regard to the advantages offered to the public, trade and industry by the development of motor transport. B, desirability of coordinating road and rail transport. Desirability of preventing the deterioration of the road system. And D, promoting effective competition among the transport service providers may from time to time by notification of the official gazette issue directions both to state transport authority and regional transport authority regarding the passengers' convenience, economically competitive fares, prevention of overcrowding, and road safety. Now, the question which had been raised before the learned single judge was, these competitive fares, if it can be fixed by the state government, who does it cover? Because the concept of aggregator is not there in section 67 at all, and is only in 93, and for which, my lord, there are no rules that have been made. Then your lordship will kindly see 2. Any direction under subsection 1 regarding the fixing of fares and freight for stage carriers, contract carriages, and goods carriages may provide the such fares of freight shall be inclusive of the tax payable by the passenger or the consignor of the goods, as the case may be, to the operators of the stage carriages, contract carriages, or goods carriages, under any law for the time being in force relating to tax on passengers and goods. Provided that the state government may subject to such conditions as it may deem fit, with a view to achieving the objectives specified in clause D of subsection 1, relax all or any of the provisions made under this chapter. Therefore, my lord, the question was, if you fix a fare, and a fare fixation insofar as the contract carriage is concerned, we do admit is within the province of the state government. It can exercise that power. But can you now exercise that power to now say that an aggregator will charge a specific fee? And if you can do that, what is the process to be adopted? Those were the questions before the learned single judge. Now, learned single judge will not, in my respectful submission, errs in saying that you are practically a transport service provider today.
Pardon?
Learned single judge holds that you are practically a transport service provider. And you are not an aggregator. It may not lead to a very anomalous situation where the state takes a position they are aggregators, and therefore they are bound not by the rules made in the year 2016 for aggregators. Learned single judge says you are transport service providers and therefore fall within section 67 and therefore controlled by section 67, because otherwise you will be outside and you will be an aggregator. Now, in my respectful submission, that is a dichotomy which cannot be broken. And that dichotomy cannot really be, cannot be reconciled, because you have a provision which deals with aggregators and what we are supposed to do. And the finding is section 67 applies because you are a service provider, a transport service provider.
Is a cross petition also?
Please, my lord.
Is a cross petition, cross appeal?
Please, that's on the very short point, my lords, because only on issue number 11, man. If they are finished, can I?
We'll set down for final hearing.
Please, my lord.
Now, my lord, the difficulty is the fair notification, my lord, has been upheld.
What interim order can be granted?
There's nothing.
No,
no interim.
no, there are two parts, my lord. One is the finding with respect to the so-called service provider. That is one part of it. The second, my lord, is there's a reference to the Competition Commission by the order of the High Court. Now, please see the order, my lord. There are some people who make allegations against us. We have, of course, responded to those allegations. No findings on that. But a direction issued by the learned single judge. Can I request, my lord, to look at that direction issued by the learned single judge? At page, my lord, 416 in volume 2.
Internal page 113, I mean, of the judgment. 113.
285.
Internal page 113.
285 of the judgment.
282.
Huh. Not 113.
No, sorry, 282.
Can I request, my lord, to kindly come to page 413, my lord, of the judgment in volume 2. Answer to point number 13 at page 413. This was not, my lord, an issue which was raised before the court. It was not as if the state government had raised it or anyone else did. And it was not a question, my lord, which we had raised either. Now, some third party comes and makes certain allegations. We respond to it. There's no finding on those allegations. But please see, my lord, ultimately, what the court holds, if I may humbly request, my lord, to come to page 416 at para 23.5. 416. 23.4, my lord, and 23.5. These are factual aspects. These are factual aspects the court cannot consider. Allegations made by the permit holder require an inquiry and evidence to be led and would come within the purview of the Competition Act 2002 and the amendments thereto. If the submissions made by the interveners is correct, then there is a cartelization which is resorted to by the aggregators who would be enterprised within such definition of the Competition Act, which has resulted in an anti-competitive agreement by abusing their dominant position in combination with each other, which would have to be inquired by the Competition Commission. Now, I ask myself, Lord, the finding of a dominant position under Section 4 of the Competition Act is an extremely involved decision-making process. Now, the court then says, para 23.6, Competition Commission is a specialization agency that has been established for such purposes. This court neither has jurisdiction nor the wherewithal to ascertain if the allegations made by interveners and defenses made out by petitions are correct or not. Interveners would always be at liberty to approach the Competition Commission. Then, Lord, Registrar Judicial of this court is directed to forward a copy of this order to the chairperson, Competition Commission of India, for information and action, if any required. Now, Lord, this, in my humble submission, is practically a scenario where the Competition Commission will be obliged to now take action against us when we've placed our defense in respect to the allegations made. There is no finding on the allegations, and there's no, my lord, return of a finding saying, yes, a prima facie there appears to be something or some truth to it. But to say that it will be referred to by this honorable court to the Competition Commission, In my humble submission, my lord, will lead to a situation where today the Competition Commission will be obliged to investigate. And I understand, my lord, in the earlier past, it's already been done. And those orders have been set aside by the NCLT in appeal against the order of the Competition Commission. Now, in my challenge, my lord, to a fair fixation by the government, I am put in a disadvantageous position in being told that now you'll face inquiry by the Competition Commission of India. And not also the finding that I'm a transport service operator, which means necessarily tomorrow the government can come back and say, you need a permit for all these operations. You need to take license. There has to be drivers who are registered. All of them will become obligations of a permit holder under Section 67 or Section 66, because the permit holders are defined under Section 66 and are covered, Lord, with respect to the fair fixation under Section 67. Now, that will result, Lord, in a very chaotic situation so far as aggregators are concerned. And it's not just here, it will be throughout the country. Every state, Lord, has different aggregator rules, which have been framed, Lord. Central government has made a guideline for aggregator rules, which require, Lord, 80% of the fare to be paid to the owner of the vehicle, who uses it for a cab, as a cab or an auto rickshaw, and Lord, 20% for the aggregator. Now, here the state government says 5% for the aggregator. And the balance, Lord, is for the person, Lord, who's actually running the cab or the auto rickshaw driver. It creates, Lord, in my humble submission, a certain dichotomy which we can't bridge. If an aggregator becomes a permit holder, Lord, then I have to be the owner of the vehicles. And the concept of a transport service provider is only in the context of a permit holder. Yeah.
What is your say?
This is a case, my lords, where we have stopped auto drivers, auto aggregators, we prohibited them, my lords. In an order of prohibition, my lords, without permission, my lords, without license, my lords, these petitioners who are Ola and Uber, my lords, are carrying on the business. In fact, my lords, there's an interim, there's no stay of that order. Your lordship may kindly order dated 11/10/2022 at page number 532, my lords. We have virtually told them not to carry on the business of aggregation. There is no stay of that order. In spite of that, my lord, they are carrying on the business of aggregation. My lord, therefore, my lord, what they are doing as on today is illegal, my lord. This order of 11th October 2022, that is at page 532, Annexure N. Your lordship may kindly see, my lord.
Page?
Annexure N. Volume 3, my lord. Annexure N, Volume 3. Can I read it, my lord? Annexure N, page 532, my lord. Annexure N, page 532. With reference to the above, as per the discussion held on 11/10/2022 regarding reply given to the notice dated 6/10/2022 and 10/10/22, it is hereby directed stop operation of auto rickshaw cabs on your app immediately. This is challenge and not stayed. In spite of there no being stay, my lords, they are carrying on the business of aggregation of auto. Therefore, the issue before the learned single judge is regarding price. Normal's price, what the learned single judge pending that writ petition said that fix a price at fix a fare, my lords.
At 10%.
Fix a fare at 10%, subject to the state refixing the fare. We gave an opportunity to them, heard them, and fixed the fare at 5%. That doesn't give them the right even today to, my lords, apply the auto through aggregation, my lords. So therefore, my lords, all these arguments saying that we have a right to apply, section 93 will not apply. All the auto rickshaw drivers have permit, my lords. There's no problem on that. They're carrying on their business, the auto drivers, without the Uber or Ola. The question is, my lords, whether the petitioners have a right, without there being a rules or regulations framed, a right to carry on aggregation, my lords, of auto drivers. In fact, in view of this order, my lords, which is challenged and which is not stayed, they have absolutely no right, my lords. They're carrying on illegally, my lords, even as on today. There are no license under section 93. There are no rules framed under 93. And what the rules my learned friend was relying upon is only pertains to 2016, only pertains to four-wheelers, my lords. Under the guise of four-wheelers license, they're running three-wheelers, two-wheelers, everything, my lords. Two-wheelers are pending before the single judge, my lords. And insofar as three-wheelers, there's already an order and not been stayed. Therefore, my lords, this is a case which your lordships have to hear finally, my lords. It's not a case of interim orders.
This, my lord, if I may just point out, this order which the learned advocate general is pointing out at page 532 was subject matter of a challenge. And in that, my lord, a specific order was passed not to precipitate anything with respect to us. First, please see page 559. Kindly see page 559.
543 is the order, my lords.
The order is at 559. The order is at 559.
Not to precipitate, that's all.
1 second, sir. And then, Lord, learned single judge holds that the aggregator license is only one for everything. That is what they're challenging now before your lordships. Please see, my lord, para 23 at page 559. All the contentions to be urged by the parties are left open to be considered in the main petition. In view of the above, respondents or their representatives shall not take any coercive action till the next date of hearing. And then the fee fixation or the fair fixation happens. And the fair fixation is challenged before single judge. They raise a question as to whether without an aggregator license specifically for autos, can they proceed? Learned single judge holds an aggregator license separately is not required for autos. Because the concept of an aggregator, my lord, is ultimately an online marketplace, nothing more. It is not an online marketplace for one or the other. It is an online marketplace for everything. And therefore, that intermediary is protected. Now, my lord, this order with respect to those 2 points, in my humble submission, my lord, will wreak havoc on us. Insofar as intermediate, either we are intermediaries or we are something else. Now, the learned single judge holds we are transport service providers. That is not a stand taken by anybody till now.
Well, any date, fix any date, my lord, final hearing, we are ready.
Till then, Lord, let them.
Sir, may kindly see, Lord, can I take 11.1? That's writ appeal number 1049 of 24. Lord, kindly looks at that.
Yes. Oh, hard copy.
Where is the signing of transport service providers? 17.8. This is an exact paragraph. Right. Well, I had the benefit of an interim order all through the writ petition. An interim order was granted by this court, staying the fee notification initially. Now, my lord, by virtue of this order, practically, my lord, everything has been undone in some ways. And a scenario has been created where I have been classified completely differently. It couldn't have been. It couldn't have been that I will classified contrary to the act itself. But the act prescribes who I am and tells everyone, my lord, who I am.
My lord, only thing, my lord, they are entitled to only collect 5%. It's ultimately, my lord, the common person who is going to be affected, my lord. We have fixed a fare under section 67, my lord. What we said is, fare or above the fare which we have fixed, you can entitled to collect 5% over and above is your commission which you have collected. Now the question is, my lord, if that is stayed, they will go and collect whatever they want, my lords. The question is, a fare is fixed after considering various aspects, my lords. So therefore, my lords, as a first thing, my lords, they are not prohibited from carrying on as an aggregator for three-wheelers, my lords, auto. Second thing, my lords, now what they're saying is by virtue of stay of the fare, they can collect what they want and they can apply the autos, my lords, as an aggregator, which cannot be permitted at an interim stage, my lords, without a valid license. And there are no rules also, my lords. If under the 2016 aggregator, it only pertains to four-wheelers. Let them point out the rules with regard to auto, my lords. There's no rules as on today.
Learned single judge's finding, my lord, specifically is that aggregators are aggregators.
No, that's factually, your lordship may kindly see the finding of the learned single judge is, your lordship may kindly see the finding with regard to that. In which quota 3, half file is there? Thank you.
Where's the interim order copy? We have a copy of the interim order here, Poonacha. We not filed it. Eat.
Please, my lords. Just page 301, just two paragraphs, my lords. Page 301 of the appeal memo. Can I request, my lords? 301, my lords, 301. Oh, sorry, 401, my lords. I stand corrected, 401. The Mr. Dhyan's appeal, that is internal. That 21.5, my lords. Page number 401. 401, para 21.5. The submission in this regard is that any vehicle adapted to carry more than 6 passengers would be a motor cab, and license issued for a motor cab or auto rickshaw carries less than 6 passengers would also cover auto rickshaw. The submission of both the senior councils that the guidelines of 2020 are mandatory and are required to be followed. Though I have held that the same to be only persuasive and not required to be followed, as per perusal of Form 3, the said guidance would indicate that a license to operate as an aggregator under Motor Vehicles Act is required to be followed in the column number 5. It is indicated number of auto rickshaws, motor cabs, motor vehicle, bus as per the list indicated by the aggregator in Form number 1 as may be applicable. This would indicate that the license has to be separate for each of the above type of vehicles, and one license would not suffice for all kinds of vehicles. Furthermore, a list of all the vehicles is required to be enclosed by the aggregator in Form 1 when initially they apply for license, and Form 2 when seeking renewal. Form 7 in Form number 1 indicate the number of type of vehicles proposed to be operated. Enclose a separate list of containing vehicle number, permit particulars of each vehicle. Now, row 7 indicate the type of vehicles. Said vehicle read in consonance with Form 3 would mean either an auto rickshaw, e-rickshaw, motor cab, motor vehicle are all not at all jointly. Therefore, what my learned friend is saying, arguing today is, if I have got then my lords, page 304 on page 221.9, my lords. The whole purpose of the guidelines appears to be that all details are required to be made to the authority concerned, and these details are to the knowledge of the aggregators. This aspect has been violated, and action would have to be taken if the guidelines have been adopted in the state of Karnataka. If the same has not been adopted, this aspect would not be much relevance. Be that as it may, even as per the argument advanced by the Learners Council, the guidelines 2020 are applicable, and the single license would cover auto rickshaw is not born out of the guidelines 2020. So therefore, my lords, my learned friend's argument that can I complete please? My learned friend's argument that with one license I can carry on anything and everything is not correct as per the 2020 guidelines, my lords. So therefore, my lords, all these aspects have to be considered at the stage of final hearing, my lords. Now, my lords, what they're seeking is by virtue of interim order without license, my lords, they want to carry on the business of aggregation, my lords. Therefore, humbly pray, my lords, any date, my lords, will prepare a short note, my lords, on a submission. The matter can be heard and disposed of.
Insofar as those two findings are concerned, my lord, calling us a transport service operator, that cannot be, my lord, under section 67. Because I can't be a transport service operator because I don't hold permits to vehicles. I'm barred from holding vehicles. If I hold vehicles, my lord, I'll cease to be an intermediary. Because I have to maintain that distinction between vehicles which are owned by third parties who put it up on the platform for the purpose of hire by someone else. They are permit holders. They are the service operator. Now, this finding that I am a service operator can't be there against me. First. Secondly, my lord, the direction to the Competition Commission that the Registrar Judicial must send it to the Competition Commission. That in my humble submission can't be there. And therefore, ultimately, that also is something which your lordship will have to consider. If, my lord, on the basis of this order, my lord, and tomorrow they start asking us,
That
yes,
is,
my lord. Please see that finding, my lord.
So far, that has already been sent on 20th June 2024. Man.
Yes, ma'am, but insofar as that, it can't be action by Competition Commission on the basis of this order. Page 23, para 23.6, last 4 lines. Last 5 lines, my lord. Registrar Judicial of this court is directed to forward a copy of this order to Chairperson Competition Commission of India for information action if any required.
I'm representing R8 in this, my lord, interveners. Represent R8, my lord, intervener, my lord. My lord, in this, actually the committee has been formed by this honorable single judge and all the stakeholders, my lord, including the Auto Rickshaw, Taxi Drivers Association, Owners Association, and aggregators has been taken place. In that, the majority, except the aggregators, all of the other stakeholders' opinion was that it should not be more than 5%. That's what the day held on the meeting itself. I request the honorable court even to direct the transport department to submit that minutes of the meeting.
This is a question. No, let it be on. Because now the difficulty for us is, Lord, it becomes a completely unviable scenario. It's completely impossible not to perform it in this way. And ultimately, there's a lot of benefit to customers, Lord. It can't be said. It is very easy on the other side to stand up and say that it does not, Lord, customers come to the app not for the purpose of ultimately being able to get this benefit.
Let it come.
At 2:30. Can it be at 2:30 live? Lord, can I also request, my lord, yes, can I make another request, my lord, with respect to transport service provider finding? The finding with respect to transport service provider, that we are transport service providers, not aggregators. Not allowing, no. It will now amount to a scenario where I'll have to obtain permits for the vehicles. I can't obtain permits for the vehicles. My lord, as an aggregator, legally I can't obtain permits for the vehicles.
That's not correct, my lord. Insofar as this is concerned, my lord, let it be stated insofar as page 23.6, my lord. Rest of it will not affect them, my lord.
23.6.
23.
That is CCI. No. So far as not the finding.
23.6, what your lordship mentioned, my lord, let that be
One
stated, my lord.
One second. Huh? 17.12, my lord. Can I humbly request, my lord, look at 17.12. That will be good. 17.12, my lord, the finding is at page 346. It therefore fails to reason, first para, as to how it can be contended before this court that Uber is not providing transport service. That would run contrary to section 2A, 1A itself. And my learned friend, my lord, the Advocate General can't have an objection because we are ultimately being asked to apply for aggregator license, not as a permit holder. No, we are not. We are an aggregator. We are under 93.
What they're saying, my lords, we are
not under
money.
67.
What they're saying is we'll collect
Or
money,
under
but we have
66.
no responsibility.
Responsibility is there. You've put those responsibilities in the rules. Please make those rules.
You're not, my lord.
We don't, my lord, in so far as the determination of fare is concerned, we come under 93 at best, not under 67.
For a consumer, my lord, what happens is they'll say we give you the auto, but we were not providing service. That means the driver is yours. Whatever happens in the auto, we are not responsible. They having given the customer the auto, it is they are providing the service to the customer, my lord. Tomorrow they cannot lift their hands away, my lord. Ultimately, for the customer, my lords, between the aggregator and the auto driver, it is they who are providing the service. Tomorrow they cannot say that we are not providing any service, but we collect money, but we will not provide service.
This argument may be a little difficult to accept because your lordships know in the context of Amazon and Flipkart, where Supreme Court has examined this entire issue, an online marketplace, my lord, has something called a safe harbor clause, where, my lord, it is impossible for for someone aggregating, either, my lord, we aggregate vehicles. Amazon aggregates people who want to sell on their marketplace. It's a marketplace. It is nothing else. It is a marketplace where someone can come and offer their goods or wares for sale to someone else. And someone who wants to buy, I can't control who buys. I can't control who sells.
It has been examined at page number 22.4, page number 408. What the single judge says is, here the customer does not select the auto. You select the auto and you send it to them. Whereas in Amazon, the shirt I select. Whatever I select on Amazon, and it will be delivered. Here, the auto is selected by them.
Auto is not selected by us.
They are selected by them because they tell, and the driver is also selected by them. Ultimately, they have to provide service.
Auto driver, I can't select, my lord. Auto driver selects the customer. When a customer makes an offer, it goes to everyone who is in the vicinity. An auto driver then chooses as to whether he wants to accept that offer from a customer to carry him.
Lord,
that is what happens
tomorrow some offense takes place in the auto. They cannot lift their hand, my lord, because it is between the auto driver and this aggregator to see the background of this auto driver, do all the background check, my lords. Tomorrow, all that, my lord, police verification, all that they have to do.
That is under the aggregator rules.
Yes,
the aggregator rules. There's a requirement that we are following.
Take the customer somewhere else.
But we can't be a transport service provider. All I'm saying is, how can we be a transport service provider under 67? For that, 66 will apply. 66 is a permit holder.
All that
no, I can't understand how.
Final hearing, this is an important question, my lord. Tomorrow, it will not only have impact here, my lord, throughout India. Tomorrow, they'll
It is the case. Every state has aggregator rules. It's the only state, my lord, where will be called a transport service provider. And every other state, my lord, we are an aggregator. Central rules, my lord, central guidelines.
He's an aggregator. He's an aggregator who's providing transport service.
No.
It's not
There is no such concept in the Act. Act, either you are a transport service provider, namely a permit holder, or you are an aggregator. It can't be both. An aggregator can't be a transport service provider.
My lords, it's simple. Permit holder is a driver, my lords. Therefore, to confuse transport service holder is different. For example, my lords, I go to a travel agent, take a taxi from him, my lords. He may not own the taxi. So ownership has has nothing to do with being an aggregator.
This is section 66, sir. No owner of a motor vehicle shall use it contrary to a permit. No, yes, not defined anywhere, but please see section 67. 67, 1D. Sixty-seven 1D. Promoting effective competition amongst the transport service providers. Not who are those transport service providers? Your lordship will find in 66. Section 66. Because this is not control of transport vehicles. No owner of a motor vehicle shall use or permit the use of the vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying any passengers or goods, save in accordance with the conditions of a permit granted or countersigned by regional or state transport authority or any prescribed authority authorizing him the use of the vehicle in that place in the manner in which the vehicle is being used. And there are only three kinds of permits. There's a stage carriage permit, a goods carriage permit, and a contract carriage permit.
Contract carriage itself is a passenger.
And what is interesting is, my lords, he wants to collect money under section 67 as transport service provider, which is fixed at 5% or whatever percent he wants. But he doesn't want to be a transport provider. When it comes to once it comes to charging, my lords, collecting the fee under 67, he agrees that he's a transport provider.
No.
So then his whole fee, the charge which is coming, is fixing the fee, is under 67.
And that is what we challenged.
No, then
96.
no, it's not under 96, my lord. Learned single judge, all the judgment says it's under 67, my lords. And what is one other sense? When it comes to four-wheelers, they accept 67. When it comes to three-wheelers, they say we 97. Very interesting argument, my lords. When it comes to four-wheelers, they say we are entitled to. When just because one wheel changes, they cannot say that we don't.
Show me, Lord, what is the four-wheeler notification of fares, or four-wheeler notification of fares expressly contemplates fixation of fee by the aggregator. So, my lord, I can't obviously have a grievance with that. My lord, can I request you to kindly look at the order for a brief minute? Kindly look at page number 6 of the order. Kindly see why is it that we gave before this, and the relief that we sought here. Kindly look at page number 6. These are my prayers. And my lord, all this argument is completely dehorsed the prayers. Kindly look at the prayers in this at page 6. I'll read it to you. Issue a writ in the nature of certiorari or any other appropriate writ or direction in the nature of setting aside or quashing the impugned notification dated 25/11/2022. That, my lord, is a notification fixing 5%, which they sought to do under section 67 instead of doing it under 96. And, my lord, our grievance about that notification was, my lord, that they must necessarily take into account all relevant parameters in fixation of fee. It is not that they can make up one day and say 5%. And not the central guidelines fixes the parameter at 20. Now they come up with 5% with no reasoning whatsoever. We have submitted to them saying these are the various services that we provide. Not any consideration of any of these things, none. Now can you look at prayer B? My prayer B is not that I am running away from fixation. My prayer B is issue a writ in the nature of mandamus or so and so to the respondents to prescribe fares in relation to auto rickshaws on aggregated platforms. So I am requesting, my lord, that they fix fares as far as under section 96, as required by not only by the central guidelines, but also by the act. Now, my lord, can you see what happened? The first round of litigation, my lord, started when they said, no, you can't fly auto rickshaws at all. Then, my lord, the first round of litigation happened before this honorable court. This honorable court said, you can't do that. You have to necessarily fix fees. Now, can I request now to kindly look at the order that was passed in that regard? May I request not in second opinion in 1.1. I don't have the page numbers in the other appeal. I will refer to the page numbers in 04. In 10. Kindly look at page 520 of 1049. It's in volume number 3.
Sure, yes.
My lord, this is the interim order that was passed in that writ petition. But my lord, I'll not trouble my lord. May I request my lord to kindly go to page 523, my lord. At 523, my lord. My lord, about 6 lines from the top of that page. My lord, the line starts with, however, in view of the submission made, page 523. 523, kindly read the 6th line from the top, man. It starts with however. However, in view of the submission made by the learned advocate general, that the state government is open and willing to formulate a fair fixation, this court is of the view that guidelines referred to above will also be adhered to during the process of fair fixation. However, since the said process would take a period of 10 or 15 days as submitted, in the interregnum, considering, I am reading the order of this honorable court in writ petition number 20349 of 22. My lord, at page 520, I am reading the portion at 523, my lord. May I read it again, my lord? However, in view of the submission made by the learned advocate general, that the state government is open and willing to formulate fair fixation, this court is of the view that the guidelines referred to above will also be adhered to during the process of fair fixation. However, since the said process would take a period of 10 to 15 days as submitted in the interregnum, considering the submissions made by the petitioner as well as the learned advocate general, this court is of the considered view that the petitioners / aggregators be put on terms. Then, in terms of the notification dated 6/11/21, issued by the Regional Transport Authority, Bangalore, so and so, meter fare has been revised in the limits of Bangalore Mahanagar Palika, and the meter rates are provided. About 9 lines later, the last word on the right side is the petitioner aggregator shall follow the fare fixed by the state as per the notification dated 6/11/21, extracted here and above, with an addition of 10% as applicable service taxes towards the services rendered by them. This would meet the ends of justice till the state government fixes a fare within a period of 15 days as mentioned. Now, post this, my lord, we made representations to them to say what are the parameters that they need to look at for the purpose of fixation of fares. Then, my lord, comes the impugned notification where they say 5% shall be the fare. Now, when they fix 5% as a share, my lord, this round of litigation comes to be filed. And my lord, may kindly see the interim order in the writ petition. May I request my lord to kindly look at page 608. My lord, may I take my lord directly to page 630, my lord, at para 28 of that interim order.
That will require homework on my part.
My lord, all that I'm saying, my lord, all that I'm saying, my lord, is this.
My lord,
all that I'm saying is this, my lord.
insofar as, my lord,
can I just complete you?
insofar as page 23 point, my lord, my lord, what my learned, my Jan saying 23.6, my lord, 23.6, it may be stayed, my lord. I have no objection.
Government says fix it at 5%, but the impugned notification says the fixation of 5% is wrong. So fixation of 5% is gone today. Today there is no fixation of fare as far as aggregator is concerned. And not all that I am saying is not. They are also even today, the learned advocate general is saying 5% should be the fare. But 5% is the fare fixed by the government in terms of the impugned notification, the notification that impugned in the writ petitions. The learned single judge says, no, it is wrong. You can't debit 5% at all. You should be treated as a transport service provider. So therefore, go back to whatever is payable to the auto rickshaw driver. That is all that is payable.
Incorrect.
So if the auto rickshaw driver was entitled to charge 25 rupees per meter, that takes into account the parameters will be, what is his cost in terms of acquisition of the auto.
5% is over and above the meter.
Yes.
Over and above. It was over and above. Now the
No, single judge permits them.
Impugned order says that notification is bad.
No, my lord, incorrect, my lord. Incorrect.
Central notification fixes it at 20%.
Incorrect, my
Now,
lord.
we said that when the fixation of 5% was done, no parameters were taken into account.
Your lordship, can you see the,
Because the interim order says 10% shall be made.
by shouting it, it will not become correct. Page, kindly see the impugned order, my lord. What my learned friend is saying is not correct. Kindly see the judge. Kindly see the judgment last, answer to point number 14, my lord. 25.2, last page of the order, my lord. It is however made clear that the aggregators would be entitled to collect 5% service charge as per the impugned notification now upheld over and above the fare fixed. That is the clear finding, my lord, that they are entitled to connect 5% over and above the fare fixed. That is the finding of the learned single judge.
That finding is contrary to the express finding.
You are aggrieved by
that.
I'm not aggrieved by that. He can charge, he's doing it. My lord, your lordship may kindly see what my learned friend is saying is totally incorrect.
Now, my lord, kindly see. the
Your
situation
lordship may
is-
kindly see 25.2, my lord.
I am a service provider, I am providing a service, my lord. I am saying I am entitled to charge, my lord, a reasonable fee as, my lord, as for services that I provide. And it's not as if the public, common public does not enjoy the service. But unless the intention of the state is to bring the service completely to a standstill.
Oh, I can understand what kind of arguments are being made.
Lord.
In fact, we let the competition commission, let all issues be argued, my lord. Your lordship may have even the 23 point, my lord, that every, if they are unreasonable, my lord, they are highly unreasonable, my lord.
But in the intervention, let the position, my lord, let the position as it existed on the date.
No,
of
my
petition
dear,
continue, my lord.
highly
Yes.
unreasonable.
25.2 is in your favor.
Yes,
No,
I
25.2.
understand, my lord.
Not so, my lord. Yeah, I show, my lord, can you look at the impute law?
Unreasonable
There's a
argument.
specific finding, my lord, that this can't be done, it should be part of the regular fare. And not in the,
So this is
my lord,
over-
my lord, there is contradicting finding in the judgment, my lord, is not.
We are concerned the operative part.
Oh, correct, my lord. In fact, I don't know why, in fact, they've been, let's be fair at least, my
If it
lord.
says the notification is bad, my lord, the notification could not have been issued. The notification is, my lord, thereafter to say I can collect 5%, my lord, that would be, dehorse the notification then, my lord. Even then I would submit, my lord, pending consideration of the correctness of this order. Let the interim order that operated during the pendency of writ petition continue.
What
That
was-
was, my lord, 10%. 10% was the order of the order in writ petition. The interim order was you can collect 10%, up to 10.
On what basis?
No basis.
No, on the basis that the central, no, the way that there was basis, I point out the order. The order considers in detail. The central government fixes it at 20%. No, the central government fixes the rates at 20%.
That's for which provision? There's no provision.
No, in fact, what basis is the question that we're asking about this 5%? Kindly see, the services that we provide has to be compensated in money. But if the order continues, we'll have to stop operations completely. But today we're not even charging a fee.
Let him give an undertaking to stop.
So this 5% was permitted by way of that notification.
Yes, my lord.
Yes,
The
5%
fair-
by the impute notification.
I'll tell you, Lordship, why the problem arose.
My lord, here.
Yeah, just take a minute.
One other important aspect, my lords.
So if you are not agreed by 25.2, then you are agreed by what?
No, can I request you to kindly look at?
We are agreed by 25.2 as well. I'll tell you, Lordship, what happened. Now, the learned single judge note, and in the most portions of the order says, you can't collect a fee over and above the fare that is fixed, which is not about 15 rupees in this case per kilometer. But in the ultimately, the operative portion says that anyway, you can charge the 5% because I'm dismissing the writ petitions. Now, that is, my lord, in my humble submission, a conflict in some way in saying in the one hand that you can only charge the fare fixed, which is fixed in the year 2021 at rupees 15 per kilometer. But what my learned friend is also pointing out is that conflict is existing in the order itself. Therefore, what we are only saying, Lord, today is, so far as the order is concerned, because there are wide-ranging statements which are made in the order, which may or may not ultimately find any muster from this honorable court, insofar as the findings are concerned, which specifically may not deal with us individually, as what we aren't, which is contrary to the Motor Vehicles Act. Our concern today, my lord, especially today, which I'm really making before your lordships as a fervent plea, is by treating us as what we are not. And then using that, my lord, to say that we should be bound by the fair fee notification may be incorrect. Which is why, my lord, I'm respectfully saying that finding on transport service operator, in my humble submission, could never have been made when there is a clear classification of an aggregator.
What are the other consequences of you being treated as?
Yes, Lord, I have a long list of consequences, Lord. If I'm a permit holder, then there are a whole bunch of requirements that I must satisfy under the Motor Vehicles Act, which I can't. And if I do that, Lord, I'll no longer be an aggregator. I'll become a permit holder. I've made, my lord, an entire list of it. May I just pass it on as to what all a permit holder must do?
But they're not permit
Yes,
holders.
no, no,
I
yes,
know.
my lord. That is
But
the
not-
concern.
We are not saying they're permit holders, my lord. They can't be permit holders.
Correct.
So
So,
they're creating an issue and trying to sort out a problem, my lord.
no.
It is not our case that they're permit holders.
No, if my learned friend says that we won't be treated as transport service operators or permit holders, then, Lord, I'm satisfied.
I will say that they're not permit holders, my lord.
No, there's no concept of transport service operator other than permit holders. Let my learned friend show it in the act if there's a definition of such a provision.
Now, how am I then classified like that by the learned single judge?
Lord, the issue arose and the conflict came to be before this honorable court based on the commission.
Hey, you have an objection to that, sir? Those 2 points you are not pushing it.
Only this one, the rest of it we can't, it's not our case also.
Why don't we just say that and close that?
We'll see, permit. The rest of it will not take the action. What's the problem? What's the problem?
I won't remember that. No, the college transport service also, there's only permit holder. No, not the matter. This, no, that is the new service notice.
Paragraph 17.20.
That is what.
22.2.
We are reading that 17.0.
Second.
No, my lord, please.
Yes, ma'am. Volume 2.
Mr.
But then this 5%.
No, but that's what your should also.
5% collection of service charge. Can also be viewed as part of the fare.
Yes, so that's a problem. My lord, if the auto rickshaw driver is permitted, my lord, 25 rupees for 2 kilometers.
30 rupees for 2
kilometers. And 5 rupees per kilometer thereafter. Now, my lord, if we read 17.2 along with the operator portion of the order, we may have to now take 5% of his fare of whatever and that was a fare fixed for all auto rickshaw drivers.
No, my lord.
Based on cost of
No, it is not like that, my lord.
Cost of petrol, cost of the service that they put in. And these are the parameters that go into consideration of what is the fixation of fare for an auto rickshaw driver. Now, to say otherwise, Lord, where is the consideration of the service that is being provided by the aggregator? We are saying that aggregator is providing an online platform. I have services, I have call centers. I make sure, Lord, I have huge data centers which are managing all of these various things. I am not only, and I am doing other services like checking on the person GPS devices, then service center for customers. There's a whole lot of services that I am providing for service for the customer otherwise. There must be a consideration.
It is been all charged to the auto drivers.
That is why they are called transport service provider. They are providing service for which they give you
No,
purpose. At one end, they say that we are providing all these services, I want money. Another end, they say, don't consider this service for liability. So the very interesting argument.
What
so
liability?
I provided all the services, but don't call me a service provider, but I'll take money.
That's why. No. This classification not been made by us. We didn't make the classification. The legislature has made a classification and said called as aggregators. Therefore, I don't know how it is available for my learned friend to argue that I am anything but an aggregator. He says you must necessarily follow the aggregator rules. You must necessarily obtain a license under aggregator rules, but I will not treat you as an aggregator. That can't be. There's a mutual contradiction in the submission.
Aggregator rules.
No, if not looks at the fare fixation notification, that fixes 5% for aggregation services. Not for, that's a completely different service. No, the impugned order, says that is not doable. Everything is part of the fare. No, the operations of these entities will come to a complete standstill. Let the status quo as it existed, by the interim order or in the writ petition, let that be continued, till this matter is heard finally. Because, if we are not able to fix fares, we will have to stop these operations. Every one of us will have to stop this operation. And then, it's ultimately the consumer who suffers. Today, to find an auto rickshaw, you have to go to the main road and see where the auto rickshaw is available. But we are providing a service where the auto rickshaw comes to your doorstep and picks you up. And for that, for the distance that he is traveling
Now
from.
this money will go where? Whose pocket?
At the end of the day, passenger.
No. Lord, there are actually, Lord, there are several.
They're not transport service provider.
The service of an aggregator, sir. Service of an aggregator is not a transport service provider. How can there be? It's not the same. Don't enforce that part. Let them not enforce that part of the order then, Lord. Insofar as transport service provider is concerned.
We can, when it is kept. 29/8 is nearer.
In this,
That one finding your lordship said, Lord, 23.2. That CCI, Commercial Competition Commission of India. The direction to
That is
23.6.
that is
23.6.
I think
same order.
23.6.
Can I only make a request, Lord, that they not impose on us the permit holder requirements now? On that basis of that observation, I think my learned friend, Lord, as the Advocate General can make that statement, because otherwise
We'll start hearing.
Please.
no, I'm requesting the Advocate General, if he can, Lord, make a statement to your lordships.
I'll be eager to take up, which is not, I'm understanding.
Please.
If I'm understanding, I may not be wary of taking it.
No, I'm saying on the,
I have not
My lord,
fully understood, so we'll take.
Cannot be required, Manoj. Let him be.
no, my learned friend anyway, my lord, can say, he has understood, my lord, so far as my learned friend is concerned, he is fully.
No, we'll take it. Because
Grateful to.
Can I only request him, my lord, to make a statement that they will not take action against us on the basis of permit
you
holders,
want to operate without any fetters.
not fetters. We are controlled by the aggregator rules.
There's no
We're
rules. There's no rules
second.
for three-wheelers.
No, but that is, the single judge has held aggregator rules apply to you for
No, no,
three-wheelers
no.
also. That you've challenged it.
Nowhere it is
You've
mentioned.
challenged it. You challenged that finding.
Aggregator rules.
It uses the word taxi, it includes all motor vehicles. And my lord, when I, as an aggregator, get a license, my lord, I have to comply with all the rules, the conditions in the aggregator license, which is what I am complying with.
Don't make me a permit holder is all we are saying.
Aggregator rules does
I
not
think my learned
mandate
friend can
that.
say that much. For all,
Let's see, we'll
for all the effort that we've taken now, I am hoping my learned friend will say something.
in this, I am appealing for the seventh respondent, my lord.
Huh?
So,
Let them take notice then, Lord, let the other parties. take
Seventh
notice.
respondent, I am
what
appearing.
about
my
the
lord.
delay we condone?
Condone, please. Manoj.
Delay is condone. Okay, so order involving one appeal will govern all.
Please,
All
Manoj. That.
Might be delay in 7.2.
That will be condoning the.
Condone.
And notice, formal notice to them.
Grateful.
29th, Lord, can I request 2:30, Lord?
Yes.
I'm very grateful.
In this, my lord, I am appearing for the seventh respondent. Copy may kindly be.
Yes, yes. We'll serve copy.
Yes. 7th and 8th.
There's one connected appeal, my lord.
What is
Connected appeal.
to be listed?
To be listed.
Appeal number so shall be listed on along with the.
This number 12. The Shaker real.
Appellant, my lord.
What is it?
Lord, appellant husband was an employee of the respondent corporation working as driver. He died in harness, my lord, on 19/2/2018. My lord, elders of the deceased workman filed an application on 15/2/2019.
So you are not, you filed the application after 1 year.
My lord, the earlier rules, my lord, the present rules existing since from December 2018, my lord. And my husband was died in the month of 9/1/2018.
Correct.
As on the date of death of
You died on 19 to 18.
19/2/18, my lord, as on the date of death of the workman, my lord, the
2001 circular was existence.
So this 1 year is provided in the earlier, before your,
Yes,
who is husband died.
limitation start from 14/12/2018, my lord. New rules came into force, my lord.
When came? 14?
Annexure F, my lord, 4/12/2018.
4/12.
2000. Earlier to this order, my lord, Annexure G, 7/5/2001 circular is in force. There is no limitation fixed for in that circular. My lord, hence she filed an application within 1 year from the new rules.
So application was made on 15/7/19. At that time, the rule of 1 year was in force.
Was in force, my lord.
That's good.
Well, 1 year, within 1 year, my lord, I filed, my lord. Rules forced into effect from 4/12/2018. She filed application on 19/7/2019, within 1 year from the date of new rules, my lord.
Correct.
London single judge stated,
Date
my
of
lord, 1 year, 5 months.
On the death of, on the date of making application, the period of 1 year was in force.
1 year was in force, commenced from 4/12/2018, my lord.
So that is the view taken by Lawrence.
My lord, within 1 year, my lord, I applied, my lord. I filed an application on 19/7/2019, my lord, within 1 year.
What is the date of application?
Earlier, there is no
1 second. What is the date of application?
application 19/7/2000, sorry, 15/2/2019. 15/2/2019. New rules came to force from 4/12/2018.
On the date of your application,
Yeah.
the rules were in force.
Earlier, there are no such rules, my lord. Earlier, my lord, no limitation was prescribed as per Annexure G.
The challenge in the heard learned advocate, Mr. So-and-so for the appellant. The challenge in this writ appeal is against the order dated 20th June 24, passed by learned single judge. Full
Well,
stop, paragraph.
one submission, my lord.
The petition came to be rejected and the prayer for compensate appointment was denied. Full stop. The only ground which rendered the application not liable to be considered was that the application was made beyond 1 year period from the date of the death of the deceased employee. Paragraph. Husband of the petitioner was a driver in the establishment of the respondent corporation. Died on 19/2/18. Application was made by petitioner wife seeking compensate appointment on 15/7/19. It was rejected on 3/8/19. Full stop. As paragraph, as stated above, the rejection was on the ground that as per the Karnataka State Road Transport Corporation, duplicate recruitment on compensate grounds, bracket over, rules 2018. Some of the applications would be filed within 1 year from the date of death of the workman. Full stop. The workman had
My lord,
died
she
on
filed within 1 year, my lord.
Full stop.
She
At the
filed
time
within
when
1
the
year.
application was made, comma, the rule providing 1 year's limitation was had already come into force. Full stop. The rule had to apply to the application of the wife, which was therefore beyond time. Full stop. Learned single judge was entirely justified in not giving relief as the application was after 1 year. Full stop. It is well settled that the right, there is no, that the claim for compensatory appointment has to strictly fall within the scheme and the rules, including the limitation wherever it is prescribed. The appeal is dismissed as meritless.
Submission, my lord, before 2018 circular, my lord, there is a circular, there is no time limit was fixed, my lord. When the new rules is coming, my lord, within 1 year, my lord, I filed my application. As per this, my lord, lordship may kindly translated copy of 2012 order, my lord, page 53, my lord. Lordship may kindly see
The rule of limitation, which was in force at the time of making application, will apply.
My lord, page 53, my lord. As per these rules, to effect the appointment, the documentation shall be conducted as per enclosure. The applications pending before these rules came into force shall be disposed in the following manner. My lord, class C, in the event, my lord, the dependents of the deceased have not made an application for appointment, then these applications shall be considered as CGA rules 2018. My lord, as on the date of death of the workman, my lord, this CGA rules is not in force.
Correct.
My lord, thereafter, my lord, earlier, my lord, there is a circular was in force from 7/5/2001. As per the circular, my no limitation was prescribed. There is some misunderstanding between the parents and others, my lord. They settle the monetary benefits belatedly. Even though, my lord, she filed an application as per new rules, my lord, within 1 year, my lord. Hence, my lord, as per new rules, my lord, they have to consider my application. But earlier, my lord, there is no limitation prescribed, my lord.
We will not repeat our order. Next.
Number 13, 14 are urgent. Number 15.
Instead of 27th may be taken from 5th, my lord. 5th September, my lord. I have informed the other side also, my lord.
That is that rep code.
Yes, rep code.
5th September?
5th of September, my lord.
Why?
27th senior council is some inquiries out of country from 23rd August till 3rd September is out of country, my lord. Senior council from Madras, my lord. Prakash. V. Prakash, whether
on 5th September, but it is for orders only.
for orders.
Good.
If you want time, we have no difficulty. We will get time in writing judgment. If you seek time, very clear, Ravi, because the time is very short and judgments are so many to be dictated. So if you
Yes,
seek
yes.
time, we have no objection, but
We-
this only we are making it clear that this matter is kept for final, for orders.
Then no. Then we have no.
27th is end.
Then is no problem.
20?
The council is appearing on your behalf.
My lord?
The council from Madras is appearing on your behalf.
Yes, my lord.
Then let it be on 5th September, don't.
Yes. Wait for a minute.
5th September. It will continue. You should not feel that it is decided in your absence, that is all. Correct.
Number 15.
Serial number 15, I appear for the complainant.
appear for the accused in this matter. Minutes, I have filed a writ appeal minutes challenging the order passed by the learned single judge. So that matter may be clubbed along with this contempt petition. Minutes, writ appeal number 979 of 2024 is filed by the accused here in minutes challenging the order passed by the learned single judge. It's a very minutes, I being a private association minutes, direction has been issued by the learned single judge. Hence minutes that writ appeal may be also minutes clubbed along with this contempt petition.
If my lords are inclined to club the matters, perhaps my lords, a date could be fixed, my lords. That would be my request.
Notice it is, notice already issued.
Sorry,
Yes.
Notice is already issued.
Notice is issued in the country.
Yes, I have filed my
What
counter
is-
as.
Who is appearing?
Not
Yes,
I appear,
accused.
Yes,
I appear for the complainant, my lords, in the
Yes.
contempt.
what do you want?
My lords, if you know, if your lordships are inclined to club the matter with the writ appeal, my lords, let there be a date fixed. My lords. That's my only request.
Writ appeal, where is that written?
Minutes, 979 of 2024 is my writ appeal.
Today it is listed.
No minutes, it was
Writ
listed
appeal
before.
number 97
979
of
of 2024.
24 shall be listed along with the present proceedings on 22nd of August.
Can it be on 27th? Can it be on 27th?
27th,
7th,
27th.
obliged.
Very well. Blessed.
Seal number 16. Abhishek Mali Patil, Shamit Nayak.
My lords. Here for the respondent, my lords. This matter pertains to the lords, petitioner's counsel is not there, but matter pertains to the admissions made by the respondent of petitioner college with respect to the medical students of the year 2015-16. What has happened, my lords? There are
Extension of time for what purpose?
my lords, that was for this honorable court in an earlier instance, my lords, ordered for the undertaking affidavit to be filed by the students for the refund of fees.
For?
There was a portion of fees was
Taking for?
a refund of fees, saying that,
Refund of fees.
please, my lords, that in case if the petitioners succeed, that is the college succeeds, there will be a portion of the fees which has to be repaid to the college, and that portion will be decided at the time of final hearing. Now, my lords, the only issue left over in this matter is that the matter which pertains, which initially started by initiation of the college, that their medical approval for the year 2015-16 was not granted, my lords. Thereafter, they approached this court and got an interim order for admitting the students with a condition that the students shall not claim equity for the year 2015-16. That was challenged by the Medical Council of India in 2015-16 within a month's time. And the Supreme Court of India said that all these admissions shall be kept in abeyance. And it then continued, my lords, about till 16-17, the same situation prevailed. And the admissions which were granted in 2015 was nullified by the Supreme Court and said that the only portion left over in the matter is to refund of the fees. With that respect, my lords, in the other connected writ petition, which was filed by the students, in writ petition number 4611, there was an order passed by this honorable court. The detailed order, my lords. Then, my lords, various aspects was considered. And then finally, my lords, the refund of fees was ordered by this honorable court with a proportion that 70% shall be deposited and 30% shall be decided at the time of final hearing. And thereafter, we filed two applications. One is for the refund of the hostel fees, and the other one is the payment of interest on the fees retained by the college. Only these two applications are now pending consideration before this honorable court, because the college have substantially refunded the amount, which is also taken by the students to a large extent. In that, my lords, one small aspect I'd like to mention, your lordships. Out of total amount of 6,14,000 paid by each of the student, my lords, 5,08,000 has been deposited by the college, out of which 4,33,000 has been withdrawn by the student. Now, the balance portion which has to be adjudicated before lordships is that whether the college has to be given any amount to be retained by the college. One is that. And second is that whether the hostel fees which is being paid by the students are required to be refunded. These are the only two aspects remains in this writ petition. Nothing else, my lords. All the other aspects have been, by the time it has been diluted. Only these two aspects are remaining for consideration. I have filed my IAs, my lords. One is IA number 1 of 17, and another one is IA number 2 of 18. IA number 1 of 17 pertains to the refund of the hostel fees paid by each of the students for about 85,000. For once, my lords, may I take my lord's attentions to order dated 20th March 2017, passed in the connected writ petition, my lords.
So today you are dealing with IA for extension of time. Which was the
Ext-
order
my lords, the
whereby,
extension of time the order dated 20th March 2017 may
so
be.
the order whereby you are required to give undertaking.
My lords, that is the order dated 20th March 2017. In
20th
the connected
March,
writ petition
one-
4611.
20th March 17.
Please, my lords. The operative portion of the order is at page
IA
61
number
of the.
1 of 24, heard learned advocate Mr. So and so. For the applicant,
1 of 24 is filed by me, my lords, respond number 75 for extension of time.
government advocate Mr. Sudev. Hegde. And learned advocate Mr.
Amit Naik,
Correspond
respond number
24.
75.
Full stop. This application is filed whereby the prayer is made to permit the applicant to file the requisite undertaking within the extended time which may be granted by the court. By order dated 20th/3/17, the applicants along with the other students was required to file the undertaking. Full stop. The applicant has stated that after the first order was passed, he had to immediately join the school, another college, which was Sir Sivu Sagur Ram Gulam Medical College, Mauritius, where the studies were started in 2017. It was stated that the family of the applicant had been staying in Haryana, and there was a difficulty in communication. It was stated that the father is a businessman and was unable to bear the financial burden. For all these reasons, the extension is prayed for. So when you will file the undertaking?
Yes, my lords.
Undertaking, when you will file?
We'll file it within 2 weeks, my lords.
You are for applicant?
No, my lords. Yes, my lords. I'm for the respond number 75 who's the applicant. Who's the applicant here? This IA has been filed by respond number 75, my lords.
So you shall that, so change it. How much time will you need?
Within 2 weeks, my lords, I'll file that.
Done, full stop. The time to file the undertaking is required in order dated 20th/3/17 is granted up to
May,
today's what? 15th September.
may I make one submission, my lords. Matter has been kept pending for 2015. Matter has been kept pending for 2015. Only one issue is remaining in the matter, my lords. If again the undertaking has been filed, it can be taken up for final hearing and it can be disposed of, my lords, on 15th of September.
Will take, the petition may be listed since it is of the year 2015 on 23rd September.
Please.
Blood.
Blood.
This is number 17.
I appear for the petitioner. An application has been filed for impleading, and I have not been served with a copy, your lordship.
My lord, I serve to all others, the state government as well as union government in the office of the state government union council office. I supplied, but I don't know the exact office of the Desai who is representing the central government.
Desai, this is with Nayak.
I heard that from the state of.
They are part.
I'll supply the office, furnish the copy.
Yes, I have to file my objections, Your Lordship.
Yes. I will furnish the copy, my lord.
Since copy of the implement application is served today, Learned Advocate Miss so and so. Raise for time to consider the filing of reply. Stand out to 24th September.
24.
Your Lordship, this is a very important matter. It pertains to mining, Your Lordship. Because of an amendment brought about by the state government, the lease period is being increased to 50 years from 30 years, Your Lordship. And no auction is being conducted for granite mining, Your Lordship. And this is in violation of the central government rules. This matter has to be heard and it is of the year 2023, Your Lordship. Your Lordship may kindly fix a shorter date.
First you get the copy, then read it, then file reply, place on record,
Please, Your Lordship.
prepare yourself, then we'll take it. By the time it will be 24th of September.
My lord, I have furnished the copy to the petitioner's clerk in his office. He has made his attestation.
I checked it.
Get the Xerox and second.
So it is in the office file copy. I have furnished the copy to them.
Second time.
Right? They have endorsed it in the petition.
Any difficulty in serving again?
Pardon?
Any difficulty in serving again?
No difficulty. I can serve one more. List.
24/9.
A shorter date, Your Lordship. A lot of loss is being caused to the state government because of this amendment, Your Lord. Auction is not being conducted at all.
They should make out a prima facie case.
Auction is dispensed.
They
No, my lord,
increasing it to
prima
50
facie-
years, 50 years.
Country
lease.
auction is introduced.
After 30 years, after expiry of a lease period, they have to participate in the auction, Your Lordship.
So she is challenging the very extent,
Yes, yes.
very rationally of extent.
No, it has been amended, my lord.
The amendment brought about by the state government, Your Lordship.
We'll see on that. That they will see.
Please.
Bill number 18,
Next date is
24/9.
24.
24.
18.
Much obliged.
18, my
the
lord, say, represent the petitioner's counsel.
The forest department is here.
That MOEF was, your lordships wanted the MOEF to make a
In
statement.
the limited time, I could ascertain one fact. Lord, that annexure J proposal, we have not withdrawn.
That was the
I-
issue, my lords, deemed
No, there's further.
government clearance.
We have not withdrawn that. We are awaiting the orders of the Honorable Supreme Court.
The stand of the Pollution Control Board is it's been revoked. That's not,
We had two stands, my lords, which
no,
is
that
not one.
specific stand is revoked. Let's check. Lords, the stand of the Pollution Control Board was that the deemed environment clearance has been revoked.
Sanction was withheld.
Lords,
Sanction was not.
No, my lords, I will, may permit me
But,
to
sir.
explain. Sir, allows me. My lords, our contention is twofold. Number one, my lords, they have applied for environmental clearance under an office memorandum dated 7/7/2021, which has been stayed by the Supreme Court. By virtue of which they could not take any benefit is our first stance. Second stance, my lords, is that the second ground on which we are objecting or we are contesting this writ of mandamus is that, my lords, they are not entitled for any benefit under Rule 8 of the EIA notification, because they have not applied it under EIA notification.
What is that?
That is, my lords, saying that they have deemed consent, deemed sanction. So, my
please
lords,
come
we,
to-
we are on these 2 points. The subset of the second point was that, my lords, the so-called Environmental Appraisal Committee report, which they rely upon as Annexure J in their writ petition, has been withdrawn. We are not saying that, my lords, it's been revoked. we are making it clear, my lords, that according to the records which is available with the Pollution Control Board, we are saying that proposal has been withdrawn. Now, my lords, only to clarify these 3 points, I had made an application, my lords, to make MOEF as a party. And my lords were pleased to allow my application. Now, my lords, MOEF through Additional Solicitor General is before my lords.
No, the Annexure J proposal, we have not withdrawn. I spoke to the secretary this morning.
What is page?
That is page
It's in the
81.
writ petition annexure J
Page.
at page
Page
81.
81, Annexure J.
81.
81 in the
81.
writ petitions. Your lordship should get the relevant portion at 116.
This is a proposal made by the expert appraisal committee. But if the question is whether we have withdrawn this, the answer is no, we have not withdrawn.
It is agenda number 6.
Yes, my lords. Agenda number 6 is consideration of by the EAC, my lords. That's the appraisal committee.
So that is pending. It is pending.
That's pending before the Supreme Court.
No, this is not pending. A learned friend is trying to mix up the issues. That is not mixed. That's not pending. Lords, what happens is, Lords, under the ECA, my lords, that's a MOEF notification of 1996. It's like this 2006, my lords. If the EAC recommends to the MOEF, my lords, EAC is the expert appraisal committee. If it recommends granting of the environmental clearance, and if the authority does not take any action on that, it becomes a deemed grant of the environmental clearance. Now, based on this, the EAC recommended, so far as we are concerned, to the MOEF. Now, after that, my lords, there is a deemed grant if no action is taken within 45 days. That 45 days gets expired, my lords, on 24 or 26th of December 2023. That, my lord, it becomes a grant, deemed grant, statutorily deemed grant. That's only regarding EC, my lords, environmental clearance, which is the subject matter of the central government. Pollution Control Board has no control on that.
Yes.
Now, my lords, on that, independently, my lords, we have to apply for this consent for establishment and consent for operation, my lords, to operate.
To the board.
To the board. Consent for establishment was granted. To secure consent for operation, my lords, we had filed our application. And the Pollution Control Board came out with a query that we have to secure the environmental clearance prior to granting me consent to operate. That, my lords, we submitted our reply saying that the MOEF, that is the Ministry of Environment and Forest and Environment, my lords, they have granted there is a deemed grant of EC, that is the environmental clearance. They did not accept. They sent one more query. My lords, we filed a writ petition saying that our writ is only mandamus, saying that they should take action to grant CFO, that is the consent. When we filed the writ at para 13, pollution control.
You are saying it is a deemed consent.
There is a deemed thing pursuant to the notification of 2000.
The question of granting.
My lords,
Law will operate, it is deemed.
there is a deemed thing that now, my lords, Pollution Control Board filed their counter before this court and stated that the proposal of EAC has been recalled. That is their stand at para 13.
Proposal of?
The expert appraisal committee, that is Annexure J, has been recalled by the MOEF. Now, MOEF is saying that has not been.
That is not.
That's not recalled. That's all. Now, beyond that, they can't go into Supreme Court's order because that's not their field.
Definitely go in. I can
How is
definitely
there,
go in
my
to
lord?
assist the court. My lords, it's
That's
not the
now
case.
it is taking
I
some
cannot-
other turn.
My lords, I have made
If at the end of 45 days, it is deemed as on one hand, and on the other hand, and Mr. Kamath says it is not withdrawn.
they have not applied under the EIA notification.
It is not for
I make-
them. Now, my
No,
lord,
it is not for me.
MOEF has to say that.
I will say,
He is not the author or.
It's my
but
turn
it's
to
a very
page number
strange,
82. My
under
lords,
which
my
I
turn to
author.
Page number 82.
So now your ten goes,
That's what, my lords. I made a.
ten disappear.
My lords, the proposal EIA notification, that's what I mentioned. My lords, my ground at the.
Now you
beginning-
are falling back upon AI.
Yeah.
No, my lord,
Now,
I-
my lord, he
all-
wants to
I-
counter MOEF, saying MOEF itself is
I am
wrong.
not saying that, my lords. My lords may look at page number 82 for a moment. Page number 82.
We'll continue.
Please.
Please, my lords.
And that's one request. That's one request. Article number 4, interim order will, serial number 1 or 2 is given hand delivery by evening.
Serial
Number 25, my lordship. Serial number 25, contempt petition. I appearing for complaint in this case. Already, order is complied by the respondent. I filed a memo already.
We'll take. After this.
18.
I appear for the second response.
The senior counsel is on his legs in another court seeking for a passover.
Matter, parted matter can't leave the court. Anyway, let's I leave it. This is,
Yes, sir. Sorry? He is appearing in video conference like for a case. He's
please.
Wait for
Orders.
Great.
Please.
yes. Yes.
Great.
Seal number 70. no? Seal number 70. 230 matter. Syed Akbar Pasha.
Therefore, complaint and what order is not complied. So far, the affidavit is filed is not served on me. But if they serve not, I'll look into it and make my submission.
The direction was only to conduct the survey and issue a e-Khata, which has been done.
Please, my lord. Not conducted, my lord.
Conducted it. Your lordship
Copy
would
is
get
served to me, my lord.
page-
I'll
Page 2 of the
look
affidavit.
into it, my lord. Now it copy is served to me. Now the copy is served to me, but I'll look into it, my lord, and make my submission, my lord.
I mean, page 2 of my affidavit, your lordship, paragraph 3. May I read, your lordship? Yes, sir.
Sorry, my lord. But the direction is to Lord, to respondent number 3 and Lord, respondent number 1. Lord, the surveyor has to conduct a survey and report to the PDO. Now the PDO has to Lord, issue e-Khata to me. Lord, as per me, Lord, there's no notice issued to me, Lord. In my presence, the survey is not conducted. And so far, Lord, e-Khata also not issued. So therefore, Lord,
Khata extract has been submitted here along with the thing. Khata. Panchayat. Like.
It's well, that's one submission. That's yeah. I'm so sorry. I'm extremely sorry, That's there's a parted matter before with Harvard Bank, sir. That's I request, I understand it's been adjourned for tomorrow, That's I have certain submissions to make, That's if it's not, it can be posted for further submission at 11 o'clock only, That's yes, That's it. I'm so sorry to interfere, That's I'm extremely sorry that I could not be here. In fact, in this matter, the AG is appearing. No, that's the reason, I would, if I know the other side is not there, tomorrow maybe at 18th matter. Tomorrow, yes, I was told it's posted for caption of orders. Let it be for hearing only, Grateful, Sorry, again.
December 71.
For the petitioner, my lord.
My lord, I appear for Huda, respondent number 3. Lord, may I make one submission? Lordship kindly permit. Made a copy.
Number 71.
In this case, Lords, I want to make one submission. Lordship kindly permit me to, Lords, one submission. If the order is passed by the Deputy Commissioner in favor of the construction of Sidrameshwara Bhavana, that is beneficiary, who is not a party to the proceedings. That beneficiary want to file application for impleading to come on record as a respondent number 6. Therefore, your Lordship kindly grant 2 weeks time, Lords, I'll file a impleading application as well as a detailed objection to this petition, Lords. 71, Lords. This respondent beneficiary is not made party in this writ proceedings, Lords. That beneficiary, Lords. Yes, Lords. In earlier writ petitions also not made party, Lords. In this proceedings also not made party. And that any orders passed by this on adverse, Lords, it will be affect the rights of the party. Therefore, my Lords, your Lordship kindly grant 2 weeks time. I'll produce all the documents before your Lordship and filed objection also, Lords. I want to file impleading application on behalf of the beneficiary. For that purpose, I'm seeking permission and sought for time.
My lords, they are not a necessary party in this petition.
They are the necessary party. The beneficiary is necessary party, Lords.
It is for the Urban Development Authority and the government to answer.
Lordship,
my
kindly
lord,
see
not the beneficiary.
Annexure B, page number 28. There the grantee is. That beneficiary is not Bowie community Bhavan, that Sidrameshwara Bhavan, that purpose site is allotted by the government. And construction is also 80% construction is completed. That is not. Yes, please.
My lords, I've been instructed to appear in this matter, my lords. I seek for a week's accommodation so that I can complete my instructions, man, please.
2 weeks not I'll search if I take.
My lords, one small submission. There is an interim order subject to the outcome of this petition. However, last time my lords had indicated that construction also, my lords, first floor has already come. And if they proceed with construction, there'll be unnecessary
Much obliged.
Seal number 20,
Thank you.
Fatima SK.
Let's complain.
For the response, Lord, we have passed an order of cancellation, Lord, and have passed an order of cancellation, cancelling the allotment made, Lord, for violation of the terms of the civic amenity site agreement. But we have cancelled the site made in favor of the builder. Lord, may kindly take page 7, Lord, the translation copy of. In the previous occasion, only the show cause notice was produced before this court, this honorable court. But now the cancellation order is also passed. Contempt, not survived. Not, we have passed an order of cancellation because since there was a violation of the terms of the allotment, or it was allotted for a cultural purpose, cultural educational purpose. In turn, what they had started using it for a clubhouse, swimming pool, other allied activities for a commercial purpose. We called upon him to submit his application explanation, and subsequently we have cancelled the allotment made in favor of the owner. Ultimately, now we'll have to, virtually, they'll have to demolish it, the entire thing.
What, plus what about the representation that is the
But
whole thing of the.
we have acted on their representation only, Lord.
The consideration of my representation wasn't sold this thing. In view of this, if they say that they're going to demolish and then consider my representation, let them.
But they being the residents association, they'll have to demolish at their cost, give it to us.
We'll
Then
have to
the
consider
purpose,
our representation for transferring the lease to us, who are the registered association. My lords. Plus, they are the registered association of the layout. Plus, they say.
Anything survives now?
Well, yes, they have still not considered our representation to transfer the lease or make a fresh lease deed, whichever they feel appropriate, my lords.
or what has now happened is,
these residents association were the residents of this layout. Not the builder who had constructed, these are all the beneficiaries of that clubhouse, swimming pool, other commercial activities in a civic amenity site, which ought not to have been done. Now, Lord, they complained to us, some of them complained to us. We said it's in terms, violation of the terms of the agreement. We canceled the agreement. Now, Lord, the clubhouse, everything will have to be demolished by them at their cost and make it, develop it and give it to us, we will transfer it. That is how it has to be done, Lord, as per the revised master plan. Not they say, the owner has a association. Now there is a another association, residents association, which says that we are entitled. Not now we have taken, already the allotment was made, CSI lease agreement was executed, possession was put in. But they came and said there is a violation. We took action on it. But they now, Lord, everything will have to be demolished. They lose their Lord, the clubhouse.
Well,
swimming pools,
demolition
everything.
is the subsequent thing. Now that they have cancelled the lease deed which is existing in favor of them, then they have to consider our representation and transfer the lease deed or make a fresh one. We will get it demolished. But
Unless,
Decide the representatives.
not unless until it is demolished, I cannot hand it over to them.
that is not a precondition
So
at all.
that is because civic amenity site, the purpose is violated. I cannot ask them, no, I cannot give them a clubhouse. But they are virtually running a spa there in the civic community site, which I cannot ask these people to run now.
That's page number 15. If your lordships were to see the WP order, my lords, it is to consider my representation dated so and so. May I just draw your lordship's attention to the WP order, my lords?
So it is decided, the layout allotted in favor of your Chaitanya Welfare Association
My lords. Earlier the lease.
is hereby cancelled. Is directed to return the original allotment letter, possession certificate. So it is
Let's pay-
cancelled.
Plus page 15, internal
fixed.
page, lots. In the WP itself, the direction is to consider my representation dated so and so. In view of the BDA having cancelled this, they're required to consider my representation and make a fresh lease deed so that these people get the CA site for the layout, who are the beneficiaries. Because my lords, without the lease deed,
You wanted this site.
well, the registered association are the beneficiaries, the layout residents are the beneficiaries of that. Without a lease deed, they will not be able to use the CA site, my lords.
Lord, sorry. As per the revised master plan of 2015, it is the developer who should hand over them. Lord, I should only facilitate it. I should only say the mode of transfer. I should only guide them. The revised master plan says the developer has to hand it over to the association. They cannot shift that burden to me. The Lord, at the end, they developed it. The builder came and he developed it. Said we provided him that this civic amenity site should be used for a cultural purpose. That they should have handed it over. Their internal dispute, my lord, they can't fasten upon us. And my lord, since there is a violation of the terms of the lease agreement, my lord, we have cancelled it. My lord, we should only say them, my lord, that it says, my lord, may I read this, my lord, the 2015, my lord, the zoning regulations, revised master plan. A minimum 5% of the total plot area shall be provided for the civic amenities, and the owner or a developer shall develop such a civic amenities, which finally shall be handed over to the local residents association for maintenance. The mode of such handing over shall be decided by the authority. And handing over has to happen from the developer or a builder to their association. That they'll have to look at. That's their internal dispute.
Two more.
Please, please.
Great.
No, allotment was in the year 2009. Allotment to the welfare builders was in the 2009. And the entire dispute started with these people in the year 2020-21. From 2009, this has been used, and these people are the beneficiaries of such a.
We will have a thought how to pass the order.
Please.
Number 21. Ram Reddy.
My lord, I appear for the contempt petitioners. The respondents have not yet filed their reply.
We have filed the reply, Your Lordship. In fact, the copy was served to the council via WhatsApp. In fact,
Yes, he's cutting of trees.
yes, Your Lordship.
Yes, madam.
In this, Your Lordship, there are previously two petitions that this honorable court has been disposed, saying that because the matter is pending before the learned single judge. Civil contempt petition number 201 of 2024 and 898.
What shall we do?
My lord, we have not received the copies. I may be provided some time to clarify if the copy has been received via WhatsApp.
Copy of the
Because as per my instruction, we have not received the copy of the reply that the my learned senior friend is mentioning.
Copy of the reply shall be given
I
to
will have
the
it served, Your
council for the complainant within 3 days. Stand over to. What is the matter? Oh. Second. 20th August.
Grateful, my lords.
Number 22, Mr. Sagar Bibi.
Paying for the. It's point number 4. And for respondent number 4, Your Lordship, I request Your Lordship kindly take the contempt papers, annexure A of the order, where I have been dispensed as a respondent. Page 16, Your Lordship, annexure A. Page 16 in my paper.
Yes.
Annexure A, Your Lordship, the learned single judge order. I request Your Lordship kindly come to page 17 for a moment. After fourth respondent is observed that Shri M.S. Nagaraj AGA for R1 to R3. Wide order dated 9/3/2023. Notice to R4 is dispensed with. R4 is the institute. It has been, R4 is the institute before the learned single judge. No notice has been served. It has been dispensed with. However, the learned single judge has observed to release the salary, but in the original order, when the EAT has passed an order, I request Your Lordship kindly take page 20 for a moment. There it says, in the circumstances, no order asks to cost, no order with regard to earlier salary. Earlier salary we are not supposed to pay. That has been suppressed. Since we have not put on our notice, we are unable to place that. Even otherwise, if Your Lordship get it in page 20 for a moment. Page 20, after para 6. I may be permitted to read para 6. Having taken the note of the factual aspect on record, the tribunal by its order dated 22nd November 2007 in E18 number so-and-so passed the following order which reads as follows. The appeal is allowed in part, the punishment is set aside, the management is directed to give the duty of Kannada cum Hindi teacher job to the appellant from January 2008 till his retirement. Next is very important. In the circumstances, no order has to cost, no order in regard to earlier salary. We are not supposed to pay the salary for earlier period. That was the order of the EAT. He filed an application, we filed a writ petition seeking for salary to consider his representation. The learned single judge has dispensed notice to us and thus directed to consider representation. When we are not a party to that, he made a representation as per annexure B.
Notice.
No, in the writ petition itself, they have not issued notice to me. Now he has made me as a accused.
24th September.
Foolish.
23rd or 27th? 20. And same, simply 23rd of.
23rd. So number 23, so Santosh BM.
Pay for the complainant in this case. For the accused, 2 weeks accommodation to file my reply.
My lord, 1 year has passed, my lord. Till today, they have not complied, my lord. A simple order, my lord.
Seeks accommodation to file my reply, my lord.
1 year has passed, my lord. Till today, they haven't complied.
That the matter is placed before the commission, my lord. We are awaiting the outcome of the decision of the commission. The matter is placed before the commission. Seeks a short accommodation, my lord, to file.
The date may be fixed.
2 weeks time may be granted.
19th September.
Grateful.
This is number 24, Mr. N. Suresh. 24.
This matter, my lord, an alternative site was supposed to be handed over to the complainant, my lord. We have made certain investigation, my lord. We are not able to find, my lord. We have written to all the zones, my lord. 2 weeks time may be granted final, my lord. We'll find out the alternative site, my lord. In fact, on the last occasion also, my lord was pleased to post the above case to today, my lord. And we have written to all the zones, my lord, to identify whether we could find another site, alternative site, my lord. 2 weeks time may be granted, my lord. In fact, we have written to the zones, my lord.
Please, my lord. Since from 23/5/2023, almost 1.5 years already gone. Both the parents are gone. They acquired the site in the 1990 and alternative site registered, but Kata not affected. That's completely disobedience on the part of this.
18th September.
18.
Public.
This is number 25, Mr. Venugopal MS.
For complaint in this case, Lord, sir. Order is already complied, Lord. Complied, Lord. Already I filed memo also, Lord.
Complaint states that the order national measures brought under the contempt jurisdiction is complied with. We have the statement made, nothing survives in the contempt proceedings. Petition is dismissed as not survived.
Please, Lord.
It will be memo dated 11/1 based on report. Learner will say that.
Number 26, Mr. Vijay Kumar K.
In this matter.
I have 2 weeks time, my lord, to file my complaint affidavit. 2 weeks time to file my complaint affidavit.
Why to?
But what has happened is, my lord, the direction is to execute a sale deed in favor of the complainant, my lord. If upon verification, it is found that, my lord, some balance amount is, the complainant is liable to pay some balance amount of the title value, my lord. The authorities are contemplating to file a review petition, my lord. The lordship will to kindly have it.
That payment is made, my lord. I filed the acknowledgement also. There was some, as per the order passed by the learned single judge, the complainant was supposed to deposit a sum of rupees 2,05,20 and 5,31,216 in respect of the sites which were given to the complainant in lieu of the land acquisition. That amount was paid in time, my lord. Since there was a delay of 2 days in generating the challenge by the respondent accused, there was a delay of 2 days. Immediately after getting the endorsement, we have deposited the amount and there is no complaints from the side of the complainant, madam. 7 acres of land was acquired and 1 site each for 1 acre was granted.
He is praying for time.
I shall verify from the record.
First October.
October. Number 27.
My
Mr.
lord, in
Chetan
serial
Kumar.
number 27, my lords, I appear for the complainants council, my lord. In this case, my lord, the accused, I appear for, my lord, the complainants council, my lord.
Amit.
The request of law and
Serial number 27, my lord.
29th August.
My lords,
Number 28. Mr. Ganesh Kumar K.
For the complaint, my lordship.
Lords, we have preferred SLP against the order passed with the Honorable
What is it?
Division Bench. My lords, we have obtained the dairy number.
My lordship, this matter pertains the life and death of the complaint, my lordship. No salary is given since July 2022, my lordship. Kindly page number 11, my lordship. Annexure, my lordship.
What do you want?
Short date may be given, my lordship.
40 code. 30th August. 30th.
Number 29. Mr. Srinivas K.
Appear for the complainant seat.
Order passed by this Ramboko.
Filed a review petition before the Supreme Court. A review petition was preferred before the Supreme Court by virtue of, after the orders of the Honorable Single Judge Division Bench and the Supreme Court with regard to some financial implications, it made necessities for us to file a review petition before the Honorable Apex Court. It was just listed on 31st, but I'm not able to get a correspondence from the council therein regarding what has transpired on 31st. May I just verify that and place it on record?
My instruction is this, my lord, this review petition was already dismissed on 31st.
Let him verify, 30th.
Kindly give a short date, my lord, so because the complainants are all retired employees. They are in the 70s and 80s.
August 30. 30 August.
Please.
30th. I need to just make a clarification and make my submissions on that.
Number 30.
I am for the complaint.
Jagdish Shastri.
Lord, the complaint, my lord, the respondent has to comply the order of this honorable court, Ashok. Is not compliant, my lord. Accused is the appointing authority, my lord. Last time he is saying that he is not appointing authority, but he is the appointing authority. I produced the appointment order, Ashok. Some of the candidates, my lord. May I see, Ashok? Ashok, kindly see the appointment order, Ashok. The other candidates, accused is the appointing authority, Ashok. But still he is misleading the court and saying he is not appointing authority. Therefore, I produced the sum of order copy itself, who has produced the accused is given the appointment to the candidate, Ashok. In another case, Ashok.
What is it? What is that?
That is, my lord, the appointment order, Ashok. Appointment order of candidates, other candidates, my lord. Accused is the appointing authority, Ashok. Accused is the appointing authority. Therefore, I produced the appointment order, Ashok.
Your lordships, on the last date, you had held that we are not the appointing authority. If KPSC could be implemented, so they can, so they may take matter in the hands, but no, they're the ones. My lords, KPSC are the ones who select the candidates and then we hereby appoint. So KPSC needs to first share the intimation with us, my lords. If KPSC could kindly be implemented in the matter.
Lord, single judge has passed the order in favor of petitioner, Lordship. Page number 34. Respondent number 3 is directed to appoint the petitioner by considering the petitioner as a candidate under the general merit category, and necessary order shall be passed within the period of 1 month, Lordship, to the effect from the date of receipt of this order. The order of served the copy to the accused, Lordship. Still it is not complied, Lordship. There is a clear-cut direction to the appoint the petitioner, Lordship.
19 September. Next.
Milord, I
Sorry,
produce the order copy, Milord, which accused is the appointing authority, Lordship. Kindly see, Lordship. Accused is the appointing authority, Lordship.
What is your case? You make it clear. I am not able to.
My
catch it.
clear is, Milord, my respondent saying that, accused is saying that accused is not a appointing authority, but he is the appointing authority.
Monday.
Milord,
Come on Monday, yes.
Milord, this is livelihood survival question, Lordship. I'm seeking appointment, Lordship. I'm seeking appointment, Lordship.
So Monday will consider.
Monday, sorry.
Please, no.
This 31, 32 urgent, December 33, so TH
For the response.
32, my lord.
It's a large 32.
Which one? 30th?
32.
33.
I am the petitioner, the complainant.
Hmm.
I don't know who has taken the adjustment.
We don't. 31, somebody has taken adjournment?
32.
32. Somebody has taken without informing you.
It is not.
Then you 32. What is it? What is it about?
It is with regard to the
Keep it on Tuesday.
much of.
Just remind us that the time was taken without consulting on that. Yes.
Much.
This is to be taken at 2:30. 32.
December 33.
Yes, please. I am for the petitioner, my lord.
Here for the
This
response.
is in respect of Goma land, my lord, which has been reduced to 3%. By 97%, they have reduced it actually. Without hearing the beneficiaries or the cattle growers or in that locality or not. As per rule 97(1) of the Karnataka land revenue rules, Your Honor, the actually 12 hectares has to be granted. Rule 97 of the Karnataka land revenue rules, 1966. Rule 97(1), my lord.
Your lordship, I kindly see subclause 4, your lordship. Your Lordship, subclause 4, Your Lordship, for KPTCL, no prior permission is required. Subclause 4 again. Lordship, 97 subclause 4. Sub 1. Ninety-seven subclause 4.
Yes, what do you say?
97, Your Lordship, what my learned friend mentioned. In that, it says for a public purpose, no permission is required. If Your Lordship could kindly see subclause 4 of 97(4). (97)(4), subclause 4, provided that no such permission shall be necessary where the reduction below the prescribed limit is for the purpose of distribution of house sites to the siteless in person and grant of land to persons belonging to scheduled caste and scheduled tribes for agriculture purpose who are ordinary residents of such village. Regularization of unauthorized cultivation under chapter 30, reservation and land for burial grounds for residents of such village, and grant or reservation of land for various government purpose, that is government schools, colleges, residential schools, hostels, hospitals, veterinary hospitals, Anganwadi, substation of Karnataka Power Transmission Corporation Limited. It is provided in the act itself, Your Lordship. So they cannot come and this is for the public purpose. It is for their own purpose that subsection is set up, substation.
My lord, under rule 108I of Kerala rules 1966, lands assigned for the special purposes under section 71 of the Karnataka Land Revenue Act shall not be granted. Shall not be granted.
108 applies only for regularization of unauthorized occupation, not for public purpose.
Rule
Learned friend has
108I and
completely mistaken.
108K.
108A is the prohibition of lands to be granted under the RUC, by the RUC committee.
108A of
I,
108I of the Karnataka Land Revenue Rules, 1966.
land revenue rules.
These apply only for those unauthorized occupations, Your Lordship. These are, 108 is the power for the regulation of unauthorized committee. This is for regularization of a unauthorized committee, not for a public purpose. 108 is completely on a different footing, Your Lordship. That cannot be applied for a public purpose at all.
So we'll consider orders for Monday.
Obliged. Right. Yeah.
So Jay Prakash Reddy.
Appearing for petitioner, my lord. Senior is held up in another court hall. Kindly pray for short accommodation.
20th September.
Much obliged.
Number 35.
I
But
appear
in
for
this-
respond number 3, my lord.
But in this matter, I am representing respondent
For
number 4.
respondent number 3, your lordship.
I have
But
to take instruction, my lord. Kindly have it after
1st
2 weeks.
October.
Lord, the extreme urgency is that, my lord, the petitioners are made to stay in extremely unhygienic condition, my lord. Big joggers have occupied a earmarked public 1.2 acres of land in Tumkur, my lord. And in extreme unhealthy conditions, the residents are made to stay, my lord. There have been several representations given from last 15 years, my lord. And when the residents have asked these illegal occupants to at least maintain hygienic conditions, they have been threatened is the instructions that I have got, my lord.
This PAL.
Yes, my lord, this is PL, my lord.
What is PAL? Let us see.
That's as far as respondent number 4 is concerned, lads, I have entered appearance only on 1st of August, but I pray for 2 weeks time to get instructions and make my submission.
Hearing pigs. One fine day, the layout man stopped migrants from constructing huts. In return, the migrants said they will be here only for few days and then leave. But the days passed, they brought up group and started living as encroachers in the side park. In fact, my lord, your lordship may kindly see from annexure from the year 2008, my lord, representations have been given by the authority, by the petitioner number 1 to several authorities, my lord, including the elected MLA, elected MP, minister, chief ministers, everything, my lord. No action has been taken, my lord. And my lord, representations was also given to the Karnataka Public Land Corporation Limited. My lord, your lordship may kindly see the said authority has addressed a letter to the president of the petitioner number 1, which is at annexure G, page number 151 for a moment, my lord. Annexure G, if your lordship may kindly see, at 161. This authority has addressed a letter to the president of the petitioner number 1 association, saying that as per the complaint given to us, we had directed the deputy commissioner Tumkur to take action on this representation. And he has written a letter to us saying that illegal encroachers have been, illegal occupants have been evacuated, my lord, which is forthcoming at page number 162, my lord. And in spite of, if your lordship may kindly see, the district collector, Tumkur district, has been instructed to check and submit a report on their complaint application of reference number so and so and so. According to the report, pig joggers have illegally constructed huts in the public area of Kumataya layout. The said encroachment has been cleared in the year 2018, along with copy of the site survey report, and the commissioner Mysore so and so and so has requested to close the said complaint. In fact, such a report has been given, my lord, but no removal of encroachment has taken place, my lord, even to this day, my lord. And admittedly, this is a park, my lord.
You are for
Respondent number 3.
December, September.
Request for a date, my lord.
11 September.
11. Grateful, my lord.
December 36. Mr. J.R. Mohan.
I appear for the respondent number 4. What's entered appearance today.
For the petitioners in this,
Request for
this is a
2 weeks.
PAL matter.
I entered appearance today, my lords. Request for 2 weeks time, my lords.
Why?
I have appeared appearance, my lords, today. I filed wakalat today, my lords.
2 weeks. Give
Please.
some date. 17th September.
17.
Publish.
Number 37.
Appearing for petitioner, my lords. Advocate on record is in another court, my lords. Place for a short accommodation.
Of the respondent number 1.
Which date do you want? September 19th.
19. December 39.
My lord, I appear for respondents 1 to 5 in this one.
Okay, each time there is allegation of encroachment, violation of sanction plan. There is a allegation and counter allegation against the respondent. Now the appellants are removing the encroachment, that means the extended area. And they are making effort. And that's a police it after a week.
Tell louder.
No. There is an allegation and a counter allegation regarding a respondent 8 to 9. They are also encroached or violated the sanction plan. Now the appellants are adjusting the sanction plan as per the plan. They are removing the excess area. Now they are doing it under progress manner. I seek a week's time to submit the report and also.
I am for the respondent number 6 and 7 in this case.
19th. 19th August.
Much obliged.
19th August.
Dharraj BH.
for the petitioner, my lord, appellants in this matter. No, this is a matter, because a subject issue was pending in Supreme Court from 2012. However, no orders has been passed, and that matter is pending in apex court when the interest of the central government, which has filed for all the transfer petitions. Our petition bit had stay orders from the single judge, my lord. Because there are no orders passed in Supreme Court and no stay has been granted even to that effect, though I was enjoying a stay order, the petition got dismissed. 3 petitions, even now, my lord, before a single judge, 1 petition on the same subject matter is pending.
September.
My lord, if an early date, my lord, if an early, because my lord, entire country in all the states, there are people who are practicing in different districts, except me, my lord, except this state.
Which date do you want?
Any convenient date your lordship see.
Tell your date.
My lord, I can't see with me. 27th, my lord, August.
27.
Oblige, my lord.
41 urgent, seal number 42. Mr. ABS Manian.
It's in serial number 42, my lords. It's, the subject matter is that, my lords, it's violation of the interim order which has been which was passed by the trial court, my lords. Notes that filed one 39-2A application before the trial court as well. That has been withdrawn by them, my lords. 39-2A applications for violations which they had filed before the trial court, that has been withdrawn, my lords. So, my lords, we permitted to file these the application which they had filed and
File in the file. Where do you want to register? Learned advocate Mr. So and so wants to file compliance affidavit. Then maybe file in the registry, stand over to 1st October.
Number 43. So
Lord.
Devraj case.
For the complainant in this matter, my lord, the order is a direction against the BBMP to restore and hand over possession of a civic amenity site which has been allotted to me. My lord, the page 31, till date, the BBMP has not filed any reply. They seem to have filed an affidavit, but my lord, may kindly see 31. I am running a school.
Reply is awaited, therefore.
My lord, may I make the submission, my lord? It's been
the petitions stand over to.
They have seemed to have filed an affidavit, but a copy has not been served. Only issue is that I am running a school that has been allotted to me for running a Kannada medium school. It has been 2 years since the date of the order. They have still not complied with that. And even the office objections, they're not complying with.
I'm appearing for respondent number 3, my lord. Appearing for BBMP.
Still, they have, even in the proceedings, writ proceedings also, it was, my only position is I can't even operate my school, set it up. My lease period is running out.
Yes.
Allowed a date, a shorter date, may I request in a copy?
That is not possible. So next.
44. Mr. Basuraj Patel, GK.
Nobody is there. Last week of October.
Right. 28. Then. Seal number 45. Jyoti.
Your Lordship. Your Lordship, in this matter, previously, the state government has filed their compliance affidavit, Your Lordship, whereas I have filed my reply to the said compliance affidavit. My lord, the matter in brief was, writ petition was, the complaint had filed writ petition seeking to consider extension of retirement and pensionary benefits on par with the old pension scheme as per the government order, Your Lordship, for which requisitions were given to them. As my requisitions were not considered, my lord, the writ petitions were filed and there was direction to consider the requisitions, Your Lordship. There are 6 complainants. My lord, after filing the content petition, they have passed a common order, which Your Lordship is at Annexure R1. My lord, there are 2 government orders, Your Lordship. First government order was 17/2/2021, wherein, my lord, the government had ordered the employees who were recruitment had done prior to 1/4/2006, but appointment was done after 1/4/2006, they could be considered under the old pensionary scheme. Whereas there was another order, Your Lordship, which is at annexure C1 and C2. My Lord, this said that the employees who are appointed under new pension scheme, for them, subsequent to 1/4/2018, my Lord, the retirement, death and pensionary family benefits to be extended on par with the old pension scheme. This is what I am praying for, Your Lordship. But whereas they have considered only with respect to the government order at annexure 3, C3, my Lord, but they have not considered annexure C1 government order. Under such circumstances,
Yes, what do you?
Yeah, we have filed the complaints affidavit in this matter. Your
Where
Lord.
is that? 5/4/24.
Yeah, 5/4. Your Lordship, you kindly see para 4, Your Lordship. An endorsement was issued on submit. It is submitted that in fact,
So it is complied with,
yes, sir.
complaint.
complied with.
No, Your Lordship.
Not
That is my grievance is what I submitted. Your Lordship may kindly may refer annexure E. It is their own department's order, my Lord. They process my papers for extending the retirement benefits as per the government order dated 28/6/2018. In page 88, Your Lordship, translation is at in page 89. Respondent number 4 directs the administrative medical officer to process the payment papers of the complainants for considering, Your Lordship, the requisition as per the government order and extend the pensionary benefits as per the on par with the old pension scheme employees. And annexure F, Your Lordship, the administrative officer does forward the papers, Your Lordship, to the Accountant General Karnataka, A and E. When such is the case, such is the development that they have already taken place. My Lord, now they have passed a common order stating that it is not only that I am asking them to consider my appointment under old pension scheme, Your Lordship. My another requisition as per reference 3 and 4 is concerned as per the government order to extend the pensionary benefits.
But they have considered.
Your Lordship, may kindly may refer the endorsement given, my Lord.
Endorsement is not considered.
At
Endorsement
page
is not
7,
favorable to you.
R1.
R1.
Endorsement is not favorable to you.
No, it is
Not
not.
favorable.
It is even not in accordance with the requisition which I have given, my Lord.
So then challenge it in separate process.
Your Lordship, it is a clear case. Kindly may refer my requisition, my Lord, at in page, Your Lordship, when it is clearly stated in page 80, my Lord. Reference number 3 and 4, government order dated 23/6/2018, government order dated 19/8/2021. With reference to the above subject, I so and so retired from service, I hereby request your consent to forward to medical officer for sanction of all pension benefits. So what is the government order, my Lord? Your Lordship may kindly may refer the government order dated 23/6/2018, which is at in page 35 translation copy, Your Lordship. Government order dated 23/6/2018. In page 33, my Lord, retirement gratuity. In the, I'll read the paragraph itself, Your Lordship. In the background of the points described in the preamble, the extension, retirement and the death gratuity and family pension benefit for the government employees subject to the new defined contemporary pension scheme who have been appointed on 1/4/2006 and subsequent dates have been granted. Retirement gratuity. In the same way, the government employment under the old pension scheme has been extended. The retirement gratuity facility has been extended to the government employees who retire under the new defined contributory pension scheme with effect from 1/4/2018, and the amount of retirement gratuity will be up to a maximum limit of 20 lakhs. Under such circumstances, they ought to have passed a speaking order, your lordship, as per this government order. Let them pass, my lord, let them say that as per this government order, I am not eligible for any pensionary benefits, your lordship.
Find out,
It is their own order also, my lord, at annexure E and F.
20th, they will find out.
Yes.
20, which is the number? 45. 20th, August,
8.
at 2:30.
At 2:30. 2:30. 46 to A. Mahesh Chaudhary.
Lords, we have complied with the orders, my lords. My
That's I-
affidavit may be taken on record.
Give copy to this.
That's in this, my lords, they have given in their compliance affidavit. The order was, my lords, that they should be giving a promotion, or they should, in case we are eligible for promotion, my lords, the impugned order was as per the seniority list dated 1/4/2021, my lords. My lords may see the order which has been passed, my lords, which is at page number 9 of today's compliance affidavit.
Come on, 26, 27.
Lords, there were certain office objection that may be overruled, my lords.
Office officers are dispensed.
Grateful.
Number 47, Paisley Butt.
There is some office objection that the respondent is supposed to comply. There is some Kannada translation is there, Kannada document is there that has to be translated.
What do you want?
But, my lands have been acquired for expansion of national highway. The compensation was there is an award. Your lordship would get it at page number 12, annexure H, A. That is the revised award. As per that revised award, they did not.
Lords, in
So you
this
have to file
matter,
translation.
Lords, we have
They have
preferred
to
a revision petition, my
Yeah.
lords, before the learned.
They have to file, you have to file translation.
File translation.
Lords.
Yeah.
I'm sorry, my lords, I'm not appearing in this.
Not appearing, so then nobody is there. 28th of September,
Earliest possibility.
30th September, sorry.
30th September. Number 48. The Chandrakant Argole.
That's-
Complaint, my lord.
Yeah,
My lords, to adjourn the matter, my lords.
Lords, in this matter, we have preferred a revision petition before the learned single judge, my lords. May I give the number, my lords?
6th November. 6th.
314.
Number 49, H.R. Vishwanath.
Prepare for the line expense.
Here again, we have filed our compliance affidavit, my lords. A revision petition was preferred and an interim order has been granted. The stay has been extended, my lords. I produced those documents.
When I made a complaint to give police protection to the complainant, on that day, one Basraj, the inspector of police, was in the Kumsi police station. I made him as a party, now replaced by one Harish Patil. But on date, on what time I made a representation to the police, then one Basraj. Therefore, Basraj made him as a accused number 3. My lord, in this matter, the police can manipulate the things, right as wrong, wrong as right. In this case, I am a complainant running a school for protection to cultural program. One fourth respondent interfering in the possession of the complainant. Therefore, he filed a suit 753 of 18 and obtained injunction order against the fourth respondent and brought to the notice of this respondent 3. In spite of that, he has not taken any action against the fourth respondent. Thereafter, I made a representation, another application for police protection before the same court, Shumaga. That application was allowed directing the police to give protection. In spite of that, they did not turn up and not respected the court order of the civil court, Shumaga. Thereafter, I filed the writ petition here on 5/1/2004. This honorable court was directed the police to give protection to perform the cultural program in the school run by the complainant. In spite of that direction, specific direction issued by this honorable court, it did not turn up. Your court has no business to direct me to give protection. I have with the law and order problem. I look after the all law and order problem. This is said by the SP. He has not given any respect to the court order. Even I brought into his notice that deliberately, intentionally disobeyed the very direction of this honorable court in not giving protection as per the direction of this honorable court, thereby disturbing in not performing the cultural program in the school. Well, therefore, with great respect, I am praying this honorable court to direct the police to give protection for performance of any other cultural program in the school and run by the complainant, and action to be taken against the police officer for having not taken and respected the order of this honorable court.
So file application. David.
Along with the compliance affidavit, my lords. Lordship may kindly see the passed against the learned single judge's order, and it has been extended time to time.
No.
Page 5, my lords.
How? They manipulating the things. That
The respondent
this honorable
police,
court-
may I take your lordships to page 6, wherein it clearly says that the respondent police is restrained from precipitating till the next date of hearing. Page 6, my lords.
My lord, on 5/1/2004, this honorable court was
Then the next page, my
directed to
lords.
give protection.
Page 8.
On this order, I made a representation on 24/1/2004 to the SP and thereafter 26/1/2024 to Sub Inspector of Kumsi. The interim order granted, that is in a review petition on 1/3/24. My representation is 24/1/2004, 1 month gap. How they connected, link with that interim order given? That is why I am not giving protection. Otherwise, I would have given high respect to the court and all. They are playing fraud over the court.
Business. Review, it is stayed in review. Order is stayed in review.
Well,
Order is stayed in the review. For the present, no contempt survive.
Please.
My lord, on the date of my representation, order was not stayed. This honorable court order was in force. How can a link with that latest order with the earlier order?
Next.
Submission, my lord. Serial number 45, kindly 22nd, my lord. It's 20th, kindly it will be taken up on 22nd, your lordship.
Which date do you want? 22nd? 22nd.
22nd. Number 50.
Therefore, the appellants, my lord, in this matter,
For the respondent statement.
PIR, my lord, filed regarding certain reserved land, reserve forest lands, my lord. I have taken out two applications, my lord. One is to implead respondents number 42 and 43. My lord, subsequent to my filing of the writ petition, my lord, respondent number 41 had filed an application to implead themselves, and my lord, that came to be allowed. My lord, in their impleading application, my lord, they refer to one allotment order, my lord, in favor of respondent number 42 and 43. Therefore, my lord, for that limited purpose, I've filed an application seeking to implead them also to this writ petition and to carry out consequent amendments, my lord. That is, my lord, IA number 2 of 2024 and 3 of 2024. Therefore, my lord, I'm just seeking, your lordship may see the relevant documents, my lord, that I have annexed to my application for amendment. Annexure A1, my lord, is the allotment order dated 19/4/2008.
What is the problem?
Hmm?
PIL.
Notice
Yes.
ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ. The proposed,
The notice has to be issued to the proposal.
proposed respondents will have to be notified.
One is the Rajiv Gandhi House Building Corporation, which is a government of Karnataka undertaking.
Lordships may see page 24, my lord, is my prayer in the writ petition. It pertains, my lord, to survey number 81 of Machuhalli village to the Karnataka Forest Department, my lord. I've sought a mandamus. In fact, my lord, on the first date of hearing, this honorable court was pleased to also stay the order dated 18/12/2017. Thereafter, my lord, respondent number 41 filed an impleading application, my lord, saying that these lands were allotted to them, that your lordship will get at order dated 1/10/2021, my lord. IA number 1 of 2021 was filed by respondent number 41. That, my lord, came to be allowed. Lord, in that impleading application, my lord, respondent number 41 had referred to two documents, my lord, by which the allotted survey number 81 was allotted to proposed respondent number 42 and 43. Therefore, my lord, I've taken steps, my lord, to implead 42 and 43, who's district commissioner, my lord, and Rajiv Gandhi Housing Corporation, who are currently in possession. Therefore, my lord, your lordship may issue notice. I'll take out notice to.
Yes, next. Give some date.
Lordship has given some date in item 50, my lord.
Date will be given. Next.
Number 51, Mr. Naveed Ahmad.
The respondent statement.
What is this? PIL.
SPIL. Regarding the widening of the road.
In September.
Who approved?
Mr. Naveed Ahmad.
Nobody is there.
No.
15th October. Is there office objection? Office objection.
Second set not filed.
It is office don't call out in all matters.
My lords, with your lordship's kind leave,
Yes.
my lord, serial number 53, my lords, I filed an application for recall. My lords, there was a peremptory order for dismissal for non-compliance in the connected matter, as a result of which my matter has also been dismissed, although there was, I had complied with the objections, my lords. Therefore, I filed a recalling. Your lordships may be kind enough to allow the recalling application, my lords.
My lords, in 53, I appear for the appealant in the first and the second matter, my lords.
53, which one, which is to be allowed?
Please, my lords,
In 53 and 53.1 and 53.2, my lords, both. 53.2.
So they are for restoration.
Restoration, my lords.
I appeal for
All
response.
restorations are given.